der Leun, Professor Bedner, Hein Halshoff, en Annette van Sandwijk. Nogmaals van harte welkom bij de faculteit rechtsgeleerdheid. The first session will be delivered by Professor van der Leun on the topic of Crimmigration Control, and the second session, Professor Bedner will talk about legal education and legal interpretation in Indonesia. The third session will be followed by Annette van Sandwijk and Hans Halshoff. Without any further ado, I will give the floor to Tirta and Professor van der Leun.
Good afternoon, ladies and gentlemen. Welcome to the session of the public lecture on Crimmigration Control, Complexities of Controlling Migration and Combating Exploitation. Our speaker today will be Professor Joanne van der Leun. She is the Dean of Leiden Law School. She's an expert in criminal law and immigration and crime migration, which she will be telling us today about what it is. Crime migration is actually not a familiar terminology here in Indonesia, I guess. From my short reading from the internet and from Joanne's article, if I'm not mistaken, it's actually about criminal law, criminology, and immigration. And I think it's about criminalizing immigrants in maybe in the Netherlands, because we don't have any quite a big issue of immigration here in Indonesia. And I think without further ado, maybe you can start with explaining to us about what is crimmigration. This session will be in English, but for those of you who would like to ask questions later and would prefer it in Bahasa Indonesia, we can provide translation for the question. Thank you.
Thank you very much. Good afternoon, all of you. I'm very happy to be here, and I'm very happy to see you here. Thanks very much for hosting us, Ibu Sulis, and everybody here. It's really wonderful to be here. I think you already gave a very good summary of the term crimmigration. Thank you very much. It's a very special word, and well, first I want to show you a little picture of a very famous former professor of Leiden University, Professor Crimmigration, because today, especially this day, we commemorate his protest lecture during the Second World War, when he opposed to the Jewish colleagues being dismissed by the Germans during the German occupation. So it's the day of commemoration today, so that's why I show you his picture. He was actually Dean of Leiden Law School at the time, and it was incredibly brave what he did, because he jeopardized himself and he jeopardized his family. So it's very hard to imagine to do such a thing. I think it's really worthwhile, even so many years later, to realize what this meant, not only for Leiden University, but for academia as a whole and society as a whole. And he was not alone, actually, but his lecture is something we really think about today. So let's go to crimmigration. I've been thinking, when I'm here in Jakarta, when I'm here in the University of Indonesia, I would like to talk about something which is in my field of research, but which is also a broader interest. So the issue of migration is actually a global issue. So within Europe, and within Western Europe and within the Netherlands, at the moment we're very aware of the issue of international migration. A couple of years ago, all the newspapers and all the media were filled with news about so-called migration crisis. The large number of immigrants arriving at the shores of Italy and Greece in little boats, looking for a place to be safe and a place to better their lives. And of course, this is not over yet, but it's not only a unique Western European phenomenon. This time is called the age of people on the move, or the era of migration, and this is only to give you an idea of how much the whole world is actually affected by migration. So of course, migration figures are always indications because we're not so sure. There are many immigrants that never show up in the registration, but here you can see the number of, if you look at the pink circles, it's the number of people who live in a region, who come from somewhere else, and it's in Asia it's 80 million, for instance, and in Europe 78 million, so that's not too different. And the orange circles are the people who actually come from the area and go somewhere else, so that's also quite big both for Europe and for Asia. And I don't want to really go deep into the numbers because it's not too interesting to talk about the numbers, and also because we're not so sure about the numbers. But one of the things I think this map shows is how much it influenced the world that people are on the move. And one of the things we can note about migration is that it's not only adults and it's not only men. Almost half of the people on the move are women, and according to these figures, 14% are children. And this is also relevant with the themes that we've been discussing before today. Children who are on the move end up in branch of law. It's becoming very much interconnected with the other branch of law. So the way she described it was, she said, the substance of migration and criminal law increasingly overlaps. So this means, for instance, within criminal law, in many instances, that new criminal offences are defined, which are actually migration law offences, but they are penalized under criminal law. For instance, if you overstay your visa and you're arrested a couple of times in the Netherlands, then you can be declared an unwanted immigrant, and then you have committed a criminal offense just by being an unwanted immigrant. And this means that a criminal law sanction can then be applied. So there are several examples where there are specific offences defined within criminal law that actually cannot be committed by citizens because it's specifically a migration law offence. So then over time you also see that this has another effect. It's not just that the law is there in a kind of vacuum and the two branches of law grow together, but this of course also has an influence on what happens at the level of implementation or the level of enforcement. And then, because they become so similar, and because people do not really make a strong differentiation between crime and migration, because they increasingly tend to overlap, then you see that there is an increase at the enforcement level of what you could call crimmigration controls. So specific controls directed towards immigrants that come to fall under criminal law. You can also see the other side. For instance, if people are punished under criminal law and they used to be immigrants with a relatively stable immigrant status, not a citizenship, not the full rights, but a relatively stable status, but they do commit crimes and they are convicted for these crimes, then there can be a migration law response. So it becomes much more easy after a criminal penalization, for instance, to be detained, prolonged of detainment, and that the government can try to deport you from the country, to evict you from the country. And this is very, very visible in the Netherlands that we are stepping up all the time. It's called so-called gliding scale. It means the more severe the criminal offense, the stronger your migration status has to be removed, but it can happen. And then every time the gliding scale, as we call it, it's not the official name, but it's the daily name, every time this scale is adapted, the threshold is lower. So this means for a smaller offense, you can already lose your residence status. So that's another symptom of crimmigration. And then we can even expand that. So we're looking at the law, then we're looking at the level of implementation and enforcement. But even on a more diffuse scale, if we talk about how we think about crime and migration, then we can see the framing of immigrants as criminals and also crime as a migrant issue. And this framing is rather strong in the Netherlands. So if you ask other people in the street about crime, it's very likely that they will come up by saying, yeah, crime is a big issue because we have so many immigrants and they commit all the offenses. We have some very popular TV shows, crime reporting shows, and they tend to show the type of crime that immigrants are overrepresented in. So the burglaries, the shoplifting, and so this framing is reinforced also in a very popular way. So in the end, it's not that there is no immigrant crime. People commit crimes. People of all walks of life commit crimes. And people in the lower strata of society commit certain type of crimes. So there is a kind of over-representation. But in the popular image, this is really conflated, and it really becomes the issue of crime being an immigrant problem. So I think this is one of the, maybe crimmigration is not so much a theoretical concept, but it's a concept that can be used to signal something that is happening in society, a signal for something that is happening in the law and in the realm of enforcement. Is crimmigration also happening in Indonesia? I've been looking into the literature, and the only article I found was by a criminologist who actually did his master's degree in Leiden. So I think the term was exported to Indonesia actually, and I might have something to do with that. But one of the things that I did not do any real comparative study of Indonesia and Europe or the United States, but what you see is that the trend is very generally visible wherever you look, but the way in which it plays out is different. And what I understood from the article by Adriaan is his name, was that it's visible mainly in the field of how the government tries to deal with illegal immigration. So there the criminalization seems to creep in. And also in the realm of human trafficking, but I'll come to that later. So this is more, I have tried to depict it here, what I have been telling. It's the two branches of law that come to merge. And as Julian Stumpf originally said, there is some kind of crimmigration law. I think it should be explained a little bit more dynamic. It's not like you have a separate subset of law that is crimmigration law. It's more the process of the two coming to overlap. And this is, of course, surrounded by this wider development of the framing of migration as a crime issue or a security issue. So this was noted first in the United States, and this is kind of a very rough timeline. It was already started, if you look back, it started long before the term was introduced. And of course there are several terms. You can always also say it's criminalization of migration, securitization of migration, etc. But it's most scholars say it started somewhere in the 1980s with increasing emphasis on enforcement of migration law. So for a long time, in the United States, it was much more accepted that you had migration law, but it wasn't necessarily enforced in practice. And this is actually very it happens a lot in migration law, that there are laws which are much stricter than the ways in which they are applied in practice. And it's very often it's more or less accepted that, okay, there's a certain element of symbolic law when it comes to regulating migration, but it's not necessarily an issue. As long as you apply it in difficult cases, it's what everybody accepts. In the 1980s, there was the first movement to say, well, we should be stricter in enforcing the law as it is. And this was gradually stepping up, which especially in the second half of the 90s, and it also had to do very much with protecting the labor market. Major changes in the policies in the United States with respect to the detention of foreigners, deportation laws, and then especially after 9/11, after the big terrorist attacks in New York and Washington and across the United States, and later also, of course, in other places. The funding for the homeland security increased massively, and to a certain extent, this also translated into much more crimmigration type of policies. I stopped drawing there. I think you can guess what happened under Trump. So I could make a big circle at the end of the arrow. I would say if we look at the situation in Western Europe and in the Netherlands, this whole process started later. If you look at the 1980s, the issue of illegal migration, irregular migration, crime immigration was hardly discussed. There were some criminological studies on very specific types of crimes where immigrants were active, but as a general issue, it was not on the societal agenda. Then somewhere in the mid-1990s, there was, actually we also called it a migration crisis at the time, or an asylum crisis, a very rapid rise in people who applied for asylum in Western Europe, and then that was the impetus to strengthen the laws and the policies. And this also branched out to the issue of irregular migration. And there, I think the Netherlands has really stepped up quickly, starting somewhere halfway the 1990s, to really try and curb illegal residents. And that's maybe not so strange if you know that the Netherlands has a very strong welfare state. So it was also an idea that this welfare state is only possible within certain boundaries of solidarity. So if you don't protect that, then either the welfare state goes down the drain, or you have to make clear who belongs to the population that can really be part of the welfare state. And it was actually I think 1995 that I got involved in the issue of studying illegal immigration and the residence of illegal immigrants in the Netherlands very long ago. And at the time when I decided to write my PhD dissertation about it, many colleagues said to me, why do you choose this subject? It's a very strange subject. And it's going to change, it won't be there in 5 years' time, because we will have the laws, we will have the laws in place and it's over and done with, and you will end up with a PhD thesis that is useless. So it turned out not exactly to be the case. Then actually this trend of crimmigration becomes visible. Well, you can see signs in the 1990s, but it really took off in the era of the terrorist attacks in the United States and later in the European countries. And now, of course, with the so-called migration crisis, and I say so-called migration crisis because it's as much a migration crisis as a crisis of European governance. It's the complete lack of solidarity and cooperation between the European member states, because they're looking at each other and they don't want to have the immigrants, they rather have the immigrants go to other parts of Europe, which in my view also very much influenced the migration crisis. So what we see here is that the trend is similar to the United States, but the timing is different, and also the legal tools that are used are different. And that's why I also assume that maybe if this is also taking place in Indonesia, the timing is probably different and the tools are probably different, and it might be visible. I'm not so sure. I'm very much interested what you think about that. So what are the implications? First of all, I would say that it increases tensions within society. If you start to look at crime as a migration issue and at migrants as potential criminals, then selective enforcement is one of the implications, because you start to enforce laws differently for people with a migration background than for other people. And this is also one of the explanations, I think, for we had a huge attention, societal attention for the issue of ethnic or racial profiling by the Dutch police over the last maybe 10 years. And this is, to a certain extent, this can be explained by the crimmigration trend, because it has become so common to have this framing of crime as a migrant issue that the police also very easily assumes that if a migrant is present somewhere in a certain kind of neighborhood, he, or mostly he, sometimes she, must be a suspect of crime. So this heightened attention for people with a migration background also caused a lot of protest within the younger generations of people with a migrant background, who feel they are part of Dutch society but are not treated as such, especially by the police. Then another development that's very visible in the Netherlands is what is called discouraging illegal or irregular migration. So this means not necessarily actively apprehending people, but more or less a policy of making life miserable. So it's very difficult to get permission to services every time and again. Your papers are checked, your permissions are checked. So very difficult to get a health insurance if you don't have strong residence status, etc., etc. So discouraging is a kind of polite word for trying to push people out, trying to discourage them. And actually, if you look at empirical studies, so people who really do fieldwork among immigrants, and they talk to, and I've done some of the work myself, if you talk to people without a residence status, this is the way they experience life in the Netherlands. It is possible to be present, it is possible to find a job, it is possible to make some money, but in the end you're fed up with it, because everything is difficult, you're not able to climb up, and also you're not able after a certain point of time when you think, well, I want to stay longer, or I would like to have a permit. It's just simply not possible, because there's no way to regularize your position, to legalize your position. You will always be stuck there, and there's no way to better yourself. So you're very dependent on family or co-ethnics. You're very dependent on your employer, and in the end people feel it's better to try their luck in another country, and that's exactly what the Netherlands wants. And of course, there's also the possibility that you do get apprehended or that you do get reported to the police, and then you can very easily be detained. So also the numbers of immigration detention shares have gone up, and that you will be deported, so you will be sent away. And again, a lot of emphasis on enforcement, because in the past, when the Dutch immigration officials would say we deported an illegal immigrant, this basically meant they brought a person to the station and put him on a train to Belgium. And this was deportation. This doesn't count anymore, apart from the fact that the Belgians didn't really like the policy and decided to do the same but the other way around. It was not really deportation, of course. It was also kind of symbolic way of saying we don't want you here anymore. Now it's much better that you get detained for a month in a row. The period that you can be legally detained is broadened, and more people are actually really deported. Still, this is the weak point of migration policy, actually, because it's not always possible. Even if the government wants to deport a migrant, the migrant still has some basic rights, and they cannot always be deported. Because even now, with all the enforcement and the new laws and the new legislations, you see that more or less half of the people who in principle could or should be deported are not deported in practice. So they are detained for a very long time, and then they are sent into the streets again. So it's not uniquely Dutch. The Dutch have been very strict, maybe in this respect, but it's not uniquely Dutch. And we see the same development in many European countries. And it's also actually the crimmigration trend is also very visible in EU migration policies. If you look closely, a so-called return directive. This means if you are found to be an illegal immigrant in one country of the European Union, you will be registered, and then you cannot go to the other country. And if you have gone to another country, you will not be able to return. And all those kind of tools have been implemented to make it more difficult for irregular or illegal migrants. So it's also very visible in EU policies. So again, what does this mean? To a certain extent, maybe it means that we have less illegal immigrants. Nobody knows. Nobody knows, because you cannot tell. And you'll never know how many people otherwise would have come to the Netherlands and now didn't come. So that might be the case. But it also implied that the number of crimes committed by irregular immigrants paradoxically went up, because it's much more difficult to make your living, so more people that do not go away start to resort to crimes. So to a certain extent, this policy really backfires, because you push immigrants underground until they become criminals. This did not really, although many people wrote articles about it and made a case in the newspapers, etc., never really impressed the government, because every time a publication was, anything was published about the rising crime, because of these stricter policies, the governmental reaction would be, we have to step up our policies, so we have to be stricter. Another implication actually is that there is more attention for types of crime in which immigrants are involved. And when I listened to some of the earlier presentations in reference to the book, it struck me. We once did a little study in the Netherlands on informal marriages in the Netherlands. So if you do not have a civil marriage before, but you do a religious marriage before that, that's punishable actually. Nobody knew, but it's somewhere hidden in the criminal law. And nobody ever really thought this could be a problem. And then suddenly, when it turned out there were some indications about Muslim marriages conducted by informal people who did a ceremony, then suddenly this was a big issue in the Netherlands. Informal Muslim marriages, this must be a huge problem, this must have to do with crime and terrorism and everything. And when you start to look and you start to reconstruct, it does take place. It usually has very little to do with crime. It has nothing to do with terrorism. It's not specifically connected to Islam. It happens in many groups, but it's another example of how these things attract attention. And this also coincided with the international attempts to combat human trafficking more intensively and more effectively. And this is where I got interested in to what extent this combat against human trafficking, which is very much put on the agenda internationally and at a supranational level, to what extent this also gets interwoven with the crimmigration trend. So it made me wonder about what about the nexus between migration and smuggling. And smuggling, as you probably know, is with consent. So a person is brought to another country, even though maybe the other country doesn't want the person, but the person wants to be brought there. So there's consent on the part of the migrant and the smuggler. If that's not the case, then there can be a case of human trafficking. So there's an interesting interconnection with the illegal immigration. So the international combat against human trafficking is really strong. I would say, maybe already over 10, 15 years now. And one of the ways in which this played out was the international attempts to be more specific about what exactly means human trafficking, because there are several laws and international agreements about trafficking, but where does trafficking begin and where does trafficking end? And this is a summary of the definition, which is actually a very complicated definition. I would say that at the core of human trafficking is the phenomenon of exploitation. So if a person is exploited, that's the core of this. The core of the crime of human trafficking, and this can involve certain acts, certain means, and a certain purpose. The purpose is exploitation. The means are some kind of coercion. It can be violence, but it can also be misusing the dependent position of the migrant, for instance, if it concerns migrants. And then the acts, it can be a recruitment, it can be harboring people, transferring people. It can involve bringing a person from one country to another, but it doesn't necessarily have to involve going from one country to another. So you can also have human trafficking, which is kind of sometimes the connotation is different. People always think you have to be brought from one country to another to be trafficked. But actually, there can be human trafficking within one country, because one person exploits the other person and uses violence or other forms of coercion. So this seems like a rather neat definition, but in the end, the core part of exploitation is very vague. When do we speak of exploitation? That is not really legally really specified. There's a lot of room in the legal documentation on what actually exploitation boils down to. In 2005, the Dutch government was adapting criminal law in order to comply with the international agreements and to adopt a new definition of human trafficking. And this definition was much broader than the old definition, which was already in Dutch law. Before, it really human trafficking always referred to the sex industry. So as of 2005, suddenly the government, more or less suddenly, was confronted with the idea that there are also other types of exploitation, and that these could, in principle, also take place in the Netherlands. For instance, labor exploitation. And they were thinking, how do we deal with this? Do we have labor exploitation? And then they asked us at Leiden University to write an advice on what does it mean, and how do we have to criminalize this, and what do we know about it. And it's very striking, but because at the time we knew very little about it. The only thing we knew came from the other studies on illegal immigrants who were sometimes working on under very difficult circumstances. And there were some cases in which you could say, well, this might be a case of exploitation, but nobody ever looked into it because they were illegal migrants and they could be deported from the country, or they could be detained, so they were never really looked at as a potential person who was exploited. So there was no attention. So this is a very a remarkable example of when you change something in the law. Sometimes we think law is very relative, but if you criminalize labor exploitation, then suddenly you start to look differently at the same situations that maybe also existed before, and you start to recognize phenomena that maybe were there already, but were never labeled or seen as such. But there's something strange happening here, because now we have this criminal label of exploitation, and we start to look at a migration phenomena, illegal labor, substandard labor, and we think, well, maybe with this criminal label we start to realize that there is something going on where the migrants are not the perpetrators, maybe, but they could be the victims. So this was really, when I was writing the advice for the Ministry of Justice, I was really puzzled. I thought this seems to be like an implication the other way around. But it's not, of course, it's not the case that all labor by illegal immigrants or irregular immigrants is exploitation as such, and there were very little cases known. Only, I think it was 2007 or maybe 2004, there was a big case all over the media in the Netherlands of labor exploitation. I think it was in the meat industry, and it was there were all these pieces in the paper that there were thousands of African migrants were exploited in the meat industry. So I started to delve into that, and it turned out to be just nothing actually. There have been some inspections by the labor inspectorate, and they had accounted some African migrants without documents. So they just called a journalist and said, we have a severe case of labor exploitation, but it wasn't documented at all. Maybe it was there, but it never been proven. So there's a kind of continuum from substandard labor, and then somewhere there's a line where substandard labor becomes exploitation. And that doesn't have to involve migrants, but given the position in the labor market that migrants have at the bottom rungs of the labor market, it's likely that migrants also end up being exploited. It's important to realize that legally it doesn't matter whether the person thinks he or she is exploited. So legally you're exploited no matter of your own perception of that exploitation. So the human rights-based approach assumes that if you are exploited, that you also feel exploited, or at least it isn't considered relevant. There is a relation with migration, and that was also something that was really in the debate on human trafficking, was not present at all in the societal debate. But it's very clear that people in marginal positions are much more vulnerable than for exploitation than any other person. And this holds especially for people without residence rights or people with weak residence rights because they lack legal protection. They can never go to the labor inspectorate and say, I'm not treated well, because they will be sent out of the country. So it's a very hidden issue. And the interesting thing is that the anti-human trafficking policy really seems to clash with the labor market protection policies. So what happened? These are some figures from International Organization, the International Organization for Migration. These are global figures, and again, I must have to say, we don't know how reliable they are, but it's the best that we have. The yellow line is the number of identified victims of labor exploitation, and these are victims of exploitation in the sex industry. So we do see that there, after a certain point of time, there's more attention. It's not so likely that there's more exploitation per se, but there's more attention for labor market exploitation and maybe less attention for exploitation in the sex industry. If we look at the Dutch figures, and this is, I could only find the figures between 2005 and 2014, but I know they're not really different after that. The blue part is the part of labor or general exploitation or labor exploitation. The red part is prostitution and exploitation for the sex industry. So what we see over time, that there is a share of other exploitation that's being detected, but it's not really expanding, and it's relatively stable over time. So it's not really the case that you see the same development as we see globally. So over time, more cases of exploitation are detected. Once there is attention for the phenomenon, you see that the number of cases detected go up. But at the same time, even though it's supposed to be punished, most of the perpetrators are never prosecuted. So in many cases, the people who conduct the exploitation are not known, or they have left the country, and so we only know about the persons that have been exploited. So in the end, these cases go unpunished. And that's only the cases that come to the knowledge of law enforcement. And it's very, very realistic that most of the cases never come to the stage where they are detected. Because it's a hidden issue, and the figures are not really going up. And it's still the case, and this is also visible in all kinds of empirical studies among police officers and labor inspectors, etc., that they still consider labor exploitation not that much of a serious issue. And even if they come in situations where under human trafficking agreements, they should at least investigate whether there is an issue of exploitation, it doesn't happen. And why is this the case? It's the case because they don't label this situation as potential exploitation. They label it as something under migration law or labor law. So they say, well, there's a case of a very bad case of substandard labor, and we can arrest the migrants concerned, and we can detain them and get them out of the country as soon as possible. So nobody really looks into the case and looks more behind the scenes what's going on and who's behind it and what's going on and whether there might be a case of human trafficking involved. So this means there's very unequal treatment and a lot of contingency when you look at migrants as victims of, or potential victims of human trafficking. So what we see is that on the one hand you could say with this anti-human trafficking policies, this would be a perfect tool to protect irregular migrants from being exploited, In practice, it doesn't happen because, again, criminalizing the migrants wins over protecting the migrants. And maybe it's even worse by conflating irregular migration with trafficking. And this is what happens all the time now. When the government writes about the policies towards illegal immigrants, it's always human trafficking is a terrible issue. Human trafficking is a terrible crime. It happens all over the world. It's one of the most profitable organized types of crime ever. And immediately you start to associate migration with this terrible type of crime. So in the end, whereas I originally thought maybe these human trafficking policies can turn this crimmigration around, it even gets worse. How am I in terms of time? 5 minutes? We had an interesting case. There are many cases of labor exploitation that were detected that are very interesting in terms of what the police did and what the prosecutor did and what the judge did. Because once some of the cases become before court, then it's very interesting what the judges do. Do they also follow this line of reasoning of seeing the immigrants as perpetrators, or do they follow the other line of reasoning and saying, well, they're victims of exploitation and they should be protected? They can actually get a residence permit. When it's clear that they're a victim of exploitation, they can get a residence permit. At first a temporary residence permit, and then the police also hopes they help with trying to find the organization behind the exploitation, but it's not really obliged. They can, after a while, get a permanent residence status. So the judges really struggled with these cases because they thought, well, how do we have to deal with the cases? And there was a famous case of Indonesian workers in The Hague and Rotterdam, and they had to bake koepuk in very hot rooms in very dilapidated houses in Rotterdam and The Hague, and their documents were taken away, so they could not go to another employer. They were sleeping in the same room as where they were working. And then the judges really struggled with the case because they said, but maybe these people wanted to work here. And maybe they were better off than when they would have gone to Malaysia or when they would have stayed in Indonesia. But then in 2009 already the Supreme Court had a landmark ruling in another case. It had to do with Chinese restaurants, exploitation in Chinese restaurants. And they said, we are in the Netherlands and we have the Dutch rule of law, so it doesn't matter whether in another country the person would have been worse, or it doesn't matter however the person looks at his or her own situation, it's the Dutch standards that apply. So this was, and many law enforcement officers struggled with that because they thought, well, this is going to be difficult because now we have to look differently at this other type of issue that we see. So, one of the aspects of this development is also that there was a lot of debate around victimhood. If you talk about trafficking, you always automatically talk about people being victims. And what turned out in these cases of labor exploitation was it didn't really seem to fit the situation, and it didn't fit the perception and the mindset of the migrants themselves, because they didn't always feel exploited, and they didn't want to be treated as victims. They didn't want victim support. They wanted money from their employers. So this also another aspect and that's why I use the word complexities in the title. It's a very complex situation where you see that it's difficult to really see where a phenomenon belongs. Does it belong to criminal law? Does it belong to migration law? Does it belong to labor market issues, etc.? So for many reasons, trafficking in human beings and trafficking in the sense of labor exploitation, you really have to actively look for it to see it. And as long as you don't have a label for it, and as long as you don't have an active policy, it will be very easy to ignore. It's also the case that because the laws are so vague, there's a lot of room to maneuver in terms of, for authorities to use more political reasoning than to really say, okay, this is a clear cut of exploitation. Because if a police officer comes across a situation in which he or she thinks there might be exploitation, officially you immediately have to report it. But in many cases it doesn't happen. And if you ask police officers, but you have these indications, why don't you look into this situation as a potential case of human trafficking? They say, but I don't have indications. There are no indications, I don't see anything. So there's a lot of room to maneuver. So including irregular migrants in this whole framing of and policy against human trafficking is a very complex step. First, because they're not considered victims by mainstream society, then because they don't consider themselves victims, and then sometimes even the human rights-based policies backfire because the immigrants are worse off than without a policy. So this is a very intricate interplay of criminal policy and migration policy, which I think shows that crimmigration is much more complex than commonly assumed. It's not just two types of law overlapping. There are much more complex dynamics at play at the level of enforcement. If you look at formal policy documents, this tension between the two policies is never recognized. You only read the sweeping statements like, it's very good we now have this anti-trafficking policy and the policy for restricted migration, and both work together very well. But as soon as migrants are concerned, you face these dilemmas, which are very difficult to solve. And sometimes there is even, you could say, sometimes there's even more protection under criminal law than there is under migration law. So crimmigration in some cases even might be might work to the advantage of migrants. So what does this all mean? Well, there are people who say maybe it's a sign that we should decenter criminal law as a solution. We shouldn't expect too much of criminal law to solve these issues, because it also puts a lot of emphasis on the individual trafficker and the criminal organizations rather than on the structural forces in our labor market, in our whole societal system, which leads to the exploitative circumstances. I always think, at least if you have a criminal law approach, you should have more prosecutions. Why else have a criminal law-based approach? Another implication that's very often noticed is that there is a need for empowering potential victims. So there should be ways in which potential victims of exploitation could somehow find a way to report what's going on, or somehow get support. And there are some pilots going on with cultural mediators now and then. I leave that out, it's too much. Maybe the main message I would say, and it's a very social legal message actually, is that the categorizations of migrants, if you try to make these neat categories and try to fit people in, then you end up with a situation that has very little to do with the empirical reality of what's going on. And that's actually what I think is happening, that the categorizations just don't really work. All the empirical research that we have clashes with these categories. So there's also, this is maybe also a call for more attention for the situational and the structural factors that cause migrant exploitation, rather than focus on the perpetrators or the criminals behind it. Thank you very much.
Thank you so much, Professor Joanne, for the inspiring lecture on crime migration. Now I know that it's not a strict theoretical concept, but it's a process of convergence of criminal law and immigration law, and that's dynamic, and I think it's very contextual to where it is, the Netherlands, European country, or Asia, or the United States, for example, and that putting it empirically is dilemmatic and problematic because it's overlapping criminal law and immigration law. You cannot define strictly whether you fall under the criminal law or the immigration law, and that especially when it comes to immigrants, once you know that he or she is an immigrant, then eventually he or she will be labeled as criminal. And I think Crimmigration, I think Ibu can actually explain the process of domestic migrant worker in our domestic migrant in the United Arab Emirates, for example, or the Arab states, because they fall under the immigration law, but they did criminal laws. And yeah, that's something interesting to see with crimmigration concept. Okay, I will no longer take your time. I will open session for 4 questions. First, one, we have 20 minutes for Q&A. Nina and then Rafika, Sulis, and one more, Mas. Tony, okay. Ibu Sulis first, I think.
Thank you so much, Professor Joanne, for a very interesting and worldwide issue we face with today. I believe that the identity of migrant people is not single. So my question is, how about the migrant with educational and professional background is treated in the Netherlands? Is there any linkage with the sociologically? Is there any linkage with the structure of the society in the Netherlands?
Thank you, Professor Joanne. My question, well, I have a comment and a question. My first, I guess, comment would be, I think in Indonesia, there's this attitude that is a gradient of crimmigration, but for trans migrants. In Indonesia, we have trans migrants, so people from Papua who move into Java, for example. And there's that attitude where then regional governments would automatically almost label these newcomers as criminals from the get-go. And that's interesting because then it's not migration per se because it's within a country, and I think that would be an interesting point to study deeper into, especially for me. But my question would be, since in Europe, Europe already has experienced migrant crisis in before World War II. How is this different? If Europe has already handled it as it has, why is today different? Is it because there's this rise of populism in politics going on, or are there other factors that are making government policies against migration different? Thank you.
Thank
Thank you, Professor Joanne. I'm Rafika from Criminology Department. I also continue the second question, and I also underline that, as you said, this crimmigration issues is a complex issue. It's a very genuine, and we cannot only see it from the migration law and merely about criminal law. And it also happened around the globe in the realm of the rising populism. I also paid attention, for example, in Australia, where people who apply for a visa can easily cancel just because he or she became a suspect of crime. So it's like a reverse of the presumption of innocence. And my question is, it's a complex issue, but initially, is that because of a gap between idea to maintain national security interests and human rights, or it is more about how the existing migration law, how the existing migration policies fail to tackle the problem of the complicated problem of immigration? And maybe you can give us insight from the Netherlands cases. Thank you.
Thank you. Well, my name is Tony. I have two questions for this season. Yes. My question is, nowadays we know in Indonesia there is some refugee, and day by day it is increasing. And of course they need to make for a living. And factually, if we know in immigration detention house or in Puncak or in Bogor, we can see they become, I can say that it's become a gigolo or something, become a sex exploitation. In your opinion, what is the solution for that? And my second question is, last year I went to Bitung in North Sulawesi, Manado. There is a problem like a stateless person. For easy example, they are not as a Philippine citizen, and they are not as Indonesian citizen. My friend is immigration officer, and they told me about their problems. They told to me, when we got them, usually they're using there is no visa, there is no passport, and my friends tried to do some coordination with Indonesian government. They said this is not Indonesian, and they tried to coordination with the Philippine embassy. They said this is not our people. So the people need to arrest, and the problem is become where to deport. It is actually happening. I want to know what's the best solution for that. Thank you.
Okay, thank you very much for some very good questions. I'll start here with you, please. I didn't say that much about other groups of migrants. For instance, more educated migrants who come to do certain jobs in the Netherlands, who are much more wanted in society, etc. But of course you're right that there are many other groups of migrants present, and that you could say that these crimmigration policies are primarily directed at those migrants in the most lower strata of society, in the most vulnerable positions. But at the same time, I have to say that if you look now at surveys among people with a migrant background who are in a much better position, they do not feel treated that well anymore. It's because of this whole framing of migrants as a problem that no matter where you are in society, you still feel that people look at you that way. So it's sad to say, but in the end it influences also those people who are much more wanted by the receiving society as well. So it's not that they directly are affected by the rules and the regulations, but they are affected by the way in which people talk about migration. And then Mina, thank you very much. I think, I've been reading a bit into the situation in Indonesia with respect to these issues, and it really struck me that maybe we should have to look at the situation of trans migrants to see comparable developments. So I fully agree, and also, of course, the issue of migrant workers maybe who go somewhere else. And that's interesting because in the Netherlands, migration is almost always international migration. And here the situation in terms of migration is different. Here it's such a big country, and you have so much internal migration and also transmigration. And so I think maybe it could be the case that this holds more for trans migrants here than for other groups of migrants. It's also another question I did not talk about is there's also a selection in which groups of migrants tend to be affected more by these kind of framing than others. And there's not always a clear explanation why that is. So it's also the case in the Netherlands and in the United States that certain groups seem to attract more negative attention than other groups, and you do not always know why. So maybe studying this particular category of migrants could maybe help understanding those differences within groups. And if I recall it correctly, you asked about how the European Union and how European countries handle this more present migration crisis other than earlier migration crisis, and what populism has to do with it. Well, first of all, there are hardly any lessons learned in migration policy. That's a very sad message, but it's true. So that's even on the very pragmatic level. For instance, in the Netherlands, the number of refugees are now going down. We know exactly that they will go up again, and we still remove all the services, etc. We dismiss the people working for the immigration service because the numbers are down. And then every time we are surprised, even in a rather planned society like the Netherlands. So apparently it's very difficult to learn lessons within migration policy. And of course population feeds into that, and migration feeds into populism. So it's very difficult to see what starts where, but it's undeniable that there's a relationship with populism. Jen, I think Africa, you talked about the reverse of the presumption of innocence. That's a really good way of saying what's going on, I think. And you asked whether it's national security first and human rights, or maybe if it's more about existing or former migration policies failing to do what they should do. That's a fair point you make. I think it's, I started out by saying it's very difficult to regulate migration. And in a time where it's difficult for governments to show that they're sovereign, for instance in Europe, to show that they're still in charge everywhere in terms of globalization, and then migration becomes an issue, and this is very difficult to govern, then it's very, it appeals to say symbolically, we regulate migration and we control migration, but at the same time, in practice, it's simply not possible. So you could even say maybe the expectations have been too high, and indeed the policies failed, but there's no way, if you want a liberal democratic way of dealing with these issues, there's no way you can do a 100% job in regulating migration. So I think the problem is that migration was seen as a point where the government could show their strength and say, we are still in charge, we regulate migration, we control who comes to our country and who does what and where and when. And in the end, it didn't turn out to be possible. So I take that point, yes. Then, you have high expectations as well, because you asked me, you asked me to solve some kind of very difficult societal issues. So the issue first of refugees becoming exploited in the sex industry. I think that's an illustration of one of the points I make. If you are very vulnerable in a society and you don't have the legal means to find your way and make your living, you will end up in criminal circles and being exploited. And the only way to get around it is to grant people the opportunity to make their living in a legal fashion. And that's very unpopular, of course, for governments who want to show I'm in charge. So that's a much more outspoken example of the same phenomenon that's visible in the Netherlands with irregular migrants. As long as they had legal channels, things were okay. But if you close them off and they don't go away and they're still there, that's one of the classical criminological theories of Robert K. Merton. If you don't find the legal ways, you will end up finding the illegal ways. So I'm afraid there is no easy solution rather than looking for ways, for better ways for people, better opportunities for people, but you have to help them. Stateless persons are the worst off. So there are several countries who try to prevent people from becoming stateless, because once you're stateless, you're in a completely hopeless situation. Yeah, because there's well, even the word thing, which country to be deported to is not clear anymore. So this is an extreme I would say it's an extreme example of how important categorizations are. If you don't even have a category anymore of a country that you belong to, then you're out on your own, and it's a terrible position. And I really believe international efforts to make it impossible for states to take away the last tie that a person has with a nation, it should be impossible, because you're in a complete and extreme catch-22 situation if you're stateless. Thank you very much.
Thank you very much once again, Professor Joanne. We still have 2 more sessions to go, so I think we end this session now. I hope your presentation will intrigue other people to do more research on crime migration. Thank you very much.
Thank you.
Next, I will invite Professor Adriaan Bedner to come to the stage, the front. Selamat siang. So we will go to the second session.
and I'm personally really pleased to be a moderator for this session, sitting here with you, an old friend and a mentor. So, and I will briefly summarize Adriaan's CV. So Adriaan is currently a PhD Professor of Law and Society in Indonesia and head of the VVI for Law, Governance and Society. His research has a particular focus on access to justice, dispute resolutions, and the judiciary. And for today's guest lecture, he will give a lecture on legal education and legal education in Indonesia and the Netherlands. A very interesting topic, and he will deliver this lecture in Indonesian. So the stage is yours.
Terima kasih banyak. Ya, sekarang sudah nyala. Oke, bagus. Jadi senang sekali saya boleh presentasi di sini di Universitas Indonesia yang sebetulnya dulu disebut Rechtshogeschool, mulai sebagai Rechtshogeschool, tapi syukurlah sekarang sudah menjadi Universitas Indonesia. Dari saya pribadi juga saya senang sekali ada perkembangan historis itu. Tapi yang menarik adalah bahwa sebetulnya sejarah pendidikan hukum di Indonesia maupun Belanda itu sangat erat, saling berkaitan. Karena akar historis itu, dan yang menjadi puzzle buat saya adalah bahwa itu memang ada perkembangan, ada perubahan yang sangat besar di dalam kedua-dua negara ini, dan hasilnya itu adalah perbedaan yang sangat dalam saya merasa dalam cara pendidikan hukum di Indonesia maupun Belanda. Jadi buat saya itu yang saya akan coba di sini adalah menjelaskan sedikit beberapa perkembangan, jadi memberi beberapa alasan kenapa perkembangan itu terjadi dan itu perkembangan seperti apa, ya, apa yang berubah di Indonesia dan apa yang berubah di Belanda. Nah, untuk itu saya mulai dengan slide. Nah, coba. Nah, ini jadi itu UI dulu di Medan Merdeka dulu itu yang di bawah itu Leiden, jadi itu alma mater saya. Nah, saya coba lihat apa yang beda waktu itu dari zaman 30-an pendidikan hukum di Belanda dan Indonesia, apa yang sebetulnya diajar di UI di Rechtshogeschool. Nah, itu mulai kedua-duanya mulai dengan introduksi kepada pengantar hukum. Ini jadi catatan saya dalam bahasa Inggris, jadi harus saya. Jadi hukum konstitusi dan hukum pemerintahan, hukum perdata, hukum acara perdata, dalam bahasa criminal procedure itu sama semuanya. Tapi karena sekarang kita ke Rechtshogeschool, di sana juga etnologi Hindia Belanda, ada bahasa Jawa, ada bahasa Melayu atau bahasa lain. Orang Belanda tidak terlalu suka bahasa Melayu karena itu dianggap bahaya, ya, nanti bisa menjadi bahasa nasional. Ada sosiologi, ada ekonomi. Jadi itu memang sangat kita lihat bahwa di sana ada sebetulnya ada interesse, ada memang minat untuk mempelajari masyarakat dan caranya berjalan komunikasi dengan masyarakat seperti berada di sana. Jadi tidak hanya hukum murni seperti kadang-kadang istilah yang kadang-kadang dipakai sekarang ini. Jadi yang di Leiden, yang satu topik yang sangat penting adalah hukum Romawi. Dan itu memang sebetulnya ada banyak pakar hukum waktu itu yang bilang bahwa hukum Romawi seharusnya juga diajar di Indonesia. Karena itu memang hukum Romawi adalah memang hukum ibu atau itu memang jadi sebetulnya hukum adalah warisan hukum dari hukum Romawi. Jadi bagaimana kita bisa mengerti hukum kalau tidak mengerti hukum Romawi? Tapi Paul Scholte, pakar hukum bukan dari Leiden tapi dari Amsterdam yang datang khusus ke Indonesia untuk mendirikan rechtshogeschool. Paul Scholte bilang itu tidak masuk akal. Jadi kalau juga ada hukum Jawa, ada hukum adat, itu semuanya sudah sangat penting. Jadi kita tidak akan bikin lebih susah lagi dengan mempelajari hukum Romawi. Saya kira itu memang satu ide yang bagus. Hanya itu bahwa di Belanda itu hukum Romawi menjadi sangat penting untuk belajar menyelesaikan kasus. Jadi misalnya kasus itu ada satu orang yang datang ke toko, dia beli sesuatu, sepeda belum ada tapi kereta atau sapi atau seperti itu. Kemudian dia bayar tapi sapinya kemudian dijual kepada orang lain. Bagaimana harus diselesaikan seperti itu? Kasus itu seperti itu yang semakin kompleks dan semakin menarik. Nah itu semuanya itu mahasiswa di Belanda belajar itu kalau mereka mempelajari hukum Romawi. Nah itu nggak ada di Indonesia. Jadi dari awalnya di Indonesia tidak ada kebiasaan, tidak ada tradisi untuk belajar menyelesaikan kasus. Ya, jadi kasuistik, pendekatan kasuistik itu sebetulnya tidak dilaksanakan di waktu itu. Itu memang harus belajar dalam prakteknya. Dan karena itu jumlah mahasiswa kecil dan itu sangat terbatas, jadi jumlah profesinya juga terbatas, jadi posisinya itu tidak apa-apa, karena memang masih mereka dapat banyak kesempatan dalam prakteknya untuk belajar bagaimana menyelesaikan kasus. Tidak usah itu dilaksanakan pada waktu mereka belajar hukum di universitas. Nah, jadi apa yang berubah di negeri Belanda sesudah itu? Sorry. Ini Fakultas Leiden sekarang ini lebih bagus, lebih besar dari yang sebelumnya. Yang berubah di Belanda adalah fokus menjadi hukum Belanda. Nah itu barangkali aneh, tapi saya tidak tahu, tapi itu memang jumlah SKS hukum Romawi sangat banyak dulu. Tapi sekarang itu semuanya berubah menjadi hukum Belanda, ya, tertulis dalam bahasa Belanda. Dan metode pendidikan juga berubah. Itu menjadi kelas kerja, kelompok kerja. Jadi tidak hanya lecturing saja, tapi itu memang ada memang jumlah mahasiswa yang harus mempelajari kasus dan bisa memang berinteraksi sama dosen mereka. Kemudian orientasi kepada prakteknya menjadi lebih besar. Jadi lebih hubungan itu apa yang harus kita belajar untuk bisa hit the ground while running. Jadi kalau saya masuk profesinya, saya bisa langsung harus kerja. Tidak seperti dulu saya belajar dulu bagaimana prakteknya sebetulnya. Dan hasilnya adalah bahwa law becomes a rather open system. Yang saya maksud itu adalah bahwa itu tidak seperti ada teori ini, ada teori itu, ada teori itu. Tapi itu memang mahasiswa hukum belajar bagaimana mereka bisa menginterpretasi hukum sebaik mungkin. Nah, itu akan saya jelaskan sedikit nanti aja. Yang kemudian yang penting sekali ada komunikasi. Komunikasi dalam artinya bahwa kalau di Belanda kalau belajar hukum harus baca dari hari pertama, tidak hanya buku mengenai tidak undang-undang, jadi sebetulnya mahasiswa hukum jarang membaca undang-undang, tapi doktrin, tapi tidak hanya doktrin, tapi juga mempelajari putusan-putusan hakim. Jadi kita coba untuk mengkombinasi sumber-sumber hukum itu supaya itu memang kita bisa mencari solusi yang terbaik dalam kasus tertentu atau kita bisa sistematisasi. Nah, apa yang kemudian berubah di Indonesia? Saya mohon maaf ini Universitas Pajajaran. Tapi saya tidak punya wifi sini, jadi tidak bisa mengganti dengan cepat. Oke, saya bisa bilang kita tidak akan ke Pajajaran, jadi mereka tidak mau ke sini lebih dulu. Jadi fokusnya adalah untuk satu sistem hukum yang sangat kompleks. Jadi ada hukum dari zaman Hindia Belanda yang berbeda dari satu kelompok dari kelompok lain, kelompok etnis. Ada hukum yang berbeda untuk masing-masing kelompok kaum religius. Ada juga hukum adat dan sebagainya. Jadi sangat kompleks sistemnya. Jadi sumber hukum sangat beraneka ragam dan itu bikin lebih susah untuk mempelajarinya dengan baik. Jadi saya sangat mengagumi pakar hukum Indonesia karena itu. Karena memang mereka harus mengkombinasi beberapa sumber-sumber. Metode teaching, saya kira itu hanya yang berubah itu hanya jumlah mahasiswa yang lebih banyak. Sebetulnya, saya melihat bahwa memang sekarang ada perkembangan baru, ada memang soal itu, tapi saya lihat masih kalau saya memang masuk satu kelompok kerja di sini, jadi jumlah mahasiswa biasanya 100. Jadi kalau di Leiden misalnya paling banyak 30, itu memang tidak boleh lebih banyak kali. Jadi interaksi antara dosen dan mahasiswa karena itu juga sangat berbeda. Apakah ada orientasi kepada prakteknya? Nah, itu menjadi masalah di setiap negara, tentunya. Tapi memang ada pengalaman saya adalah bahwa orientasi pada prakteknya itu memang kurang kalau dibanding dengan Belanda. Jadi keluhan, jadi itu pasti. Jadi pengacara selalu suka mengeluh. Tapi keluhan di sini saya kira itu kadang-kadang memang lebih tepat dalam artinya bahwa beberapa skills keterampilan itu di Indonesia memang kurang diperhatikan di dalam pendidikannya. Dan memang ada percobaan itu, tapi itu memang itu makan uang dan itu makan tidak gampang untuk mengubahnya. Nah, hasilnya dari 3 hal ini dan itu juga bahwa metode penemuan hukum itu kurang diperhatikan tahun-tahun sebelumnya, terutamanya zaman Orde Baru. Itu membuat hasilnya adalah satu sistem di mana ada formalisme, legisme yang cukup kuat, atau misalnya hakim akan menggali hukum dalam masyarakat dan caranya biasanya tidak terlalu jelas bagaimana dia akan menggali hukum. Kalau mau memang menggali hukum dengan benar harus menggunakan metode ilmu sosial. Tapi biasanya itu memang hakim mikir apa yang dia merasa adalah adil, itu ide dia sendiri lebih daripada itu memang ide masyarakat. Nah, itu menjadi satu masalahnya dan itu berhubungan bahwa itu ada opposition yang sangat dalam itu. Menurut saya alasannya adalah bahwa metode penemuan hukum itu di Indonesia kurang diperhatikan dan salah satu dan itu berhubungan juga dengan sumber-sumber hukum yang bisa dipakai. Dan itu mengenai communication dari komunikasi itu juga kalau di Belanda yang sangat penting adalah misalnya pengacara membaca juga doktrin hukum. Jadi kalau ada misalnya Pak Topo kalau menulis satu artikel di dalam jurnal mengenai hukum pidana itu pasti dibaca oleh pengacara. Kalau di Belanda, kalau di sini saya kira pengacara biasa. Masalahnya itu juga hakim juga atau ada banyak, misalnya hakim di Mahkamah Agung. Saya kenal sama hakim yang suka baca, tapi mereka harus menyelesaikan 8 kasus sehari. Jadi bagaimana kalau itu memang dosenya tebal seperti ini? Jadi bagaimana bisa membaca artikel protokol kalau harus baca ulangan satu asisten, satu hakim, nggak bisa juga. Dan banyak yang tidak percaya kepada asistennya, jadi masalah. Jadi kita lihat bahwa ini memang menjadi masalah sekarang ini, karena kalau tidak ada waktu untuk membaca untuk komunikasi seperti itu memang jadi yang hasilnya adalah semacam kemiskinan komunikasi. Dan itu memang cari solusi yang paling tepat dan yang paling baik itu menjadi lebih sulit. Nah, kalau itu so what is it that lawyers do, and is it that one, I don't know, saya lupa apa yang itu aneh sekali. And is it that one gets taught in hospital today? Waduh, itu memang bahasa itu kacau sekali. Mohon maaf. Tapi yang penting itu apa yang pakar yuridis melakukan. Itu cukup sulit ya. Kalau saya tanya sama mahasiswa dari fakultas lain di sini, biasa mereka mempelajari undang-undang itu saja. But what is what lawyers do? Jadi mereka menganalisis sumber-sumber hukum dengan menggunakan metode-metode interpretasi hukum yang memang diterima sebagai metode yang baik untuk itu, terutama yang untuk pakar hukum atau untuk legal scholars. Jadi untuk mengembangkan sistem atau untuk to determine the legal outcome, jadi melihat apa solusi yang terbaik untuk kasus tertentu. This is basically what you do. Itu memang pada dasarnya apa yang dilakukan. Nah, bagaimana ini di Indonesia? Kalau ada sumber, ada orang yang kenal batu itu apa sih? Bukan, ini hukum, ini undang-undang. Ini undang-undang yang paling Hammurabi. Siapa yang bilang itu? Hammurabi, bagus itu Hammurabi. Ini sebetulnya saya jadi teksnya sangat ngeri. Memang harus untuk orang yang harus dihukum dengan berat ya. Kalau saya mencuri sesuatu itu memang tangan saya dipotong, kepala saya dipotong, kemudian kaki saya dipotong, itu memang sedikit, tapi itu memang itu undang-undang. Tapi itu memang sumber hukum yang paling kuat, tapi memang ada sumber hukum lain juga. Nah misalnya itu jelas, itu semuanya belajar, jadi tidak harus customary international law, ada treaties, ada konstitusi, ada peraturan undang-undangan. Kemudian ada jurisprudensi, case law, ada kebiasaan atau adat, dan ada doktrin. Nah, ini menarik. Kalau di Belanda, apa yang diduga menjadi sumber yang paling banyak dipelajari oleh mahasiswa dari yang ini. Jadi siapa kira itu yang paling dipelajari itu customary international law? Gak ada. Kalau konvensi, itu penting atau tidak di Belanda? Penting. Konstitusi, penting. Peraturan perundang-undang, penting juga. Jurisprudensi, sangat penting. Sangat penting. Adat, tidak terlalu. Doktrin, sangat penting juga. Ya, jadi memang banyak sering dibaca. Jadi mahasiswa hukum Belanda harus baca terus. Saya tidak bilang Saya masih ingat, jadi ada Ibu Joanne yang pernah cerita ada keluhan dari mahasiswa karena artikelnya terlalu panjang karena dia tidak bisa baca pada iPhone-nya. Tapi itu bukan, that was not a reason to give him a short article, was it? Jadi nah, kalau kita melihat ini, yang kalau kita lihat di Indonesia, jadi Customary International Treaties, Constitution, peraturan perundang semuanya ada. Tapi itu sebenarnya jurisprudensi jarang dipelajari di universitasnya. Kalau adat, ya di adat bidang hukum adat, tapi misalnya kebiasaan di bidang hukum dagang tidak terlalu juga saya. Kalau doktrin, ya itu tergantung, tapi doktrin karena itu memang jurisprudensi tidak dipelajari, doktrin juga kurang menarik pada umumnya. Jadi banyak doktrin di tulisan-tulisan doktriner di Indonesia yang hanya menjadi sebagai penjelasan mengenai peraturan perundang-undangan, dan itu memang seperti penjelasan benar. Kadang-kadang mereka bilang itu cukup jelas, ya. Jadi saya dari itu saja. Nah, kenapa kita membutuhkan interpretasi hukum yang baik? Sebetulnya ada law subject. Nah, itu saya kenal, itu terkenal di Indonesia. Saya tahu ini Gustav Radbuch yang bilang harus ada kepastian hukum, kita cari keadilan, dan kita cari manfaat. Ya, jadi kita harus cari harus ada keseimbangan antara tiga tujuan sistem hukum. Dalam tiap kasus kita coba membuat keseimbangan antara tiga itu. Dan kita mempunyai beberapa metode interpretasi hukum yang berbeda untuk mencapai hasil seperti itu. Nah, apa metode interpretasi yang dipakai dan apakah penting di Indonesia atau di Belanda atau tidak? Nah, pertama-tama ada metode gramatikal. Satu, saya bisa menjelaskan ini satu kasus ini sebetulnya pasal dari Belanda, dan yang terjadi, yang masalahnya apakah memang laki-laki atau perempuan, biasanya laki-laki, kalau memaksa perempuan untuk dicium dengan memasukkan lidah di dalam mulutnya, apakah itu menjadi perkosaan? Itu pertanyaan yang memang harus diselesaikan oleh Mahkamah Agung Belanda. Nah, apa yang dilaksanakan itu pada dalam putusan pertamanya Mahkamah Agung Belanda bilang bahwa kalau kita lihat dalam sejarah undang-undang ini, seharusnya itu memang harus disebut perkosaan. Jadi memang ada orang yang dihukum karena mereka memaksa seseorang untuk seperti itu. Nah, tapi itu ada banyak titik, karena itu anehnya kalau perkosaan di dalam bicaraan sehari-hari di Belanda itu memang tidak dianggap sebagai perkosaan. Jadi kalau muncul jadi karena itu pada akhirnya tahun 2013 Hakim Agung di Belanda itu memang mengutamakan satu interpretasi gramatikal, artinya cara bicara biasa itu memang menyebut perkosaan adalah sesuatu hal yang lain. Jadi ini memang tidak sekarang lagi tidak bisa dihukum lagi kalau hukum memang memaksa satu orang untuk ini saya ada gambaran dari Indonesia yang lebih jelas untuk menjelaskan apa ini. Saya tahu kan bisa dilihat ini Pak Surya Dharma Ali yang bilang perempuan harus dibawa lutut. Itu ini interpretasi gramatikal. Nah, metode gramatikal itu di Indonesia itu banyak dipakai juga. Oke. Kita sekarang ke Ketua Mahkamah Agung Belanda yang dulu itu Geert Korstens. Kalian apanya roadnya, jubahnya. Lihat ini ada di sana ada yang putih dengan hitam. Apa tahu apa itu dibuat dari materi apa? Itu memang dari undang-undang itu dipaksa itu tulis harus dari Hermelijn, ermine. Di Indonesia nggak ada banyak binatang yang nggak ada di Belanda, binatang ini nggak ada. Nah, itu memang ada satu binatang, tapi yang terancam, yang mau punah. Jadi karena itu Uni Eropa bilang itu sebetulnya itu tidak bisa dipakai lagi, tidak boleh. Itu masalah kalau undang-undang Belanda bilang harus pakai itu. Kacau. Tapi dengan menggunakan metode sistematik itu bisa. Dan hasilnya seperti itu. Hakim bilang saya akan menginterpretasi undang-undang ini dalam cahaya dengan memperhatikan peraturan perundang-undangan dari Uni Eropa, dan itu memang kalau itu memang menjadi kelinci pakai cat hitam itu sudah baik juga. Tapi sistematik itu sebetulnya itu kelinci. Kita memang dalam hal ini bisa membaca Hermelijn adalah kelinci. Nah ini sistematik, bukan gramatika. Ya, jadi sebetulnya ini memang saya sedikit bertanda, tapi ini metode yang sangat penting. Maksudnya kalau memang kalau ada satu istilah dalam undang-undang tertentu, itu memang istilah itu harus diinterpretasi sama dalam undang-undang yang lain, supaya tidak ada banyak perbedaan. Nah ini di Indonesia kadang-kadang menjadi masalah, misalnya kalau kita lihat bahwa istilah sendiri tidak sama. Kalau itu juga berasa itu semuanya itu masalah itu memang kesalahan Belanda. Karena dalam bahasa Belanda itu misalnya ada tindakan onrechtmatige daad. Nah, apakah itu tindakan melanggar hukum atau tindakan melawan hukum? Itu sudah bedanya. Jadi interpretasinya kita sudah lihat di sana ada banyak masalah-masalah dalam penggunaan istilah yang definisi yang. Dan untuk sistematika itu kita tidak harus hanya mempelajari undang-undang, tapi kita harus mempelajari jurisprudensi. Apakah hakim memang dengan sistematis menginterpretasi istilah itu. Nah, ada satu metode yang sangat penting di Belanda juga, the history of the statute. Nah ini kalau di Belanda kami punya teroris yang ekstremis Islam juga. Tidak hanya di Indonesia. Ini adalah satu Samir A. Ya, nah Samir A itu memang dia mau membuat bom. Dan tadi itu memang kemudian dia ditangkap oleh polisi dan ada bahan-bahan yang dia beli untuk bikin bom. Tapi karena Samir A bukan ahli bikin bom, kalau teroris di Indonesia baik. Jadi dia beli bahan-bahan yang salah, tidak bisa meletus. Nah, ini jadi masalah buat si jaksa ya. Jadi bagaimana kita bisa menghukum dia karena itu dia bilang oke, saya mau bikin bom tapi nggak bisa. Nah, kemudian mereka melihat statute ini, apakah itu memang bisa cukup alasan untuk menghukum Samir A. Dan untuk itu hakim memperhatikan sejarah undang-undangnya. Dan itu di Indonesia itu memang sekarang sudah mulai bisa diakses. Jadi di itu memang ada penjelasan yang sangat lengkap yang dikirim oleh menteri kepada parlemen waktu undang-undang itu dibicarakan dalam parlemen. Dan ini memang seringkali itu memang aktif mempelajari namanya memori van toelichting, memori penjelasan untuk tahu apa yang sebetulnya itu memang dimaksud oleh the lawmaker. Nah, dalam hal ini memang jelas bahwa itu memang disebut bahwa kalau bahan-bahan salah itu tidak penting, yang penting adalah memang intensi. Ada memang intensi untuk melakukan itu. Oke. Metode terakhir yang sangat penting itu metode yang teleologis. Dan ini satu metode yang penting juga. Jadi apa sebetulnya tujuan satu undang-undang atau satu pasalnya? Kalau artikel 14 itu memang di Indonesia artikel 1365, ya, itu tindakan melawan atau melanggar hukum. Nah, itu salah satu kasus yang selalu dipelajari di Indonesia. Saya kira itu adalah Lindenbaum-Cohen. Ya, semuanya kenal Lindenbaum-Cohen. Saya tidak harus jelaskan.
Di sini
masih di. Ya. Nah, yang dalam kasus Lindenbaum-Cohen terjadi itu memang hakim menolak pada akhirnya satu interpretasi yang gramatikal dari yang melanggar hukum, dan hukum dianggap sebagai peraturan perundang-undangan. Tapi itu memang alasannya ada pasal itu adalah untuk menghindari ada tindakan yang memang tidak yang memang melanggar tidak moral, tapi memang katanya aturan-aturan yang berlaku dalam lalu lintas masyarakat, maatschappelijk verkeer. Yang penting itulah memang itu lebih lengkap. Itu jadi termasuk hukum the living law sebetulnya dalam hal ini. Nah, itu jelaslah bahwa hakim menggunakan idenya dari undang-undang, jadi tujuannya menjadi alasan untuk itu menjadi latar belakang untuk menginterpretasi satu pasal seperti dalam hal ini. Jadi konklusi. Nah itu satu slide aja. Yang pertama-tama, kalau kita lihat situasi di Indonesia ini, how can we go towards more legal certainty without formalism? Karena itu menjadi masalahnya. Saya kadang-kadang berkelahi dengan Prof Peter Mahmud, bukan dari UI. Karena Prof Peter itu memang, jadi pada dasarnya saya kira kami setuju bahwa kalau saya baca buku pengantar hukum Peter Mahmud, ya memang harus mempelajari jurisprudensi, harus mempelajari semuanya bisa menjadi sumber hukum. Tapi dalam prakteknya sebetulnya itu memang tidak menjadi sangat penting, tidak dipelajari, tidak digunakan. Karena itu memang yang kita harus bikin bukan perang terhadap social legal studies dan sebagainya, tapi kita harus menggunakan sumber-sumber yang ada. Kalau sumber-sumber itu belum ada, harus memang diakses. Jadi the first solution is to use case law. Dan itu sebenarnya itu bisa dipakai sekarang ini, karena itu ada 6 jadi itu hanya untuk TUN ada 6.000 kasus yang putusan lebih di website-nya. Jadi masalahnya Mahkamah dia punya waktu untuk mengorganisir. Jadi kita harus mengorganisir sendiri. Jadi saya kira itu memang tujuan, itu tugas universitas. Itu seperti di Belanda juga. Jadi itu memang kalau di bidang hukum, hukum perdata itu memang kolega-kolega saya di bagian hukum perdata itu yang melaksanakan tugas itu. Tiap minggu mereka berkumpul untuk membicarakan jurisprudensi yang paling baru. Apa yang penting, apa yang menarik. Wah, ini aneh. Bagaimana kita harus sistematisir itu? Bagaimana apa artinya? Itu jadi penting. Kalau kita menggunakan sumber yang berbeda, we can also use different methods of interpretation. Tidak hanya gramatikal atau tidak hanya menggali hukum dalam kepala hakim. Kita harus memang cari hukum dengan menggunakan metode interpretasi, misalnya dalam parliamentary records. Jadi saya masih ingat waktu dulu saya mempelajari PTUN di Indonesia. Jadi untuk itu saya harus cari di mana untuk dapat risalah dari DPR mengenai undang-undang PTUN itu. Jadi saya kemana-mana. Pada akhirnya saya dapat dari kawan di Departemen Hukum. Tapi sekarang ini semuanya dipublikasi, semuanya bisa diakses. Jadi tidak ada alasan lagi untuk tidak dipakai. Dan kemudian yang penting juga saya kira strengthening the ties between legal professions. Jadi saya kira hakim harus baca apa yang ditulis oleh profesor-profesor atau pakar lain dari universitas. Dan itu memang mereka bilang wah itu tidak menarik. Itu sebenarnya tugasnya untuk profesor adalah untuk membuat tulisan yang menarik buat mereka. Jadi mereka juga harus menggunakan waktu mereka tidak hanya untuk kalau misalnya di PTUN di tingkat pertama jumlah kasus tidak terlalu banyak. Jadi saya kenal banyak hakim yang suka mancing, suka main tenis, dan sebagainya. Kalau di Jogja di pasar ada seperti itu. Seharusnya mereka mempelajari tulisan Prof dari pakar lain. Nah, the importance of context, karena itu memang saya kira juga memang ada banyak itu sudah Ibu Mulia tadi pagi sudah bilang itu kita memang harus kontekstualisasi. Kalau Indonesia sekarang itu beda dari Arab zaman Nabi. Tapi itu juga Indonesia sekarang itu juga beda, syukurlah, puji syukur, beda dari zaman Hindia Belanda. Jadi kalau kita masih menggunakan kitab undang-undang pidana, kita memang harus melihat dalam zamannya, harus mengkontekstualisasi itu penting juga. Tapi itu juga berubah. Untuk bisa mengkontekstualisasi kita juga harus mengerti masyarakat, apa yang berubah, apa yang perkembangan baru di Indonesia sekarang ini yang sangat dari hukum adat juga tidak bisa dipakai seperti dulu lagi. Nah, dan yang paling penting harus bikin you have to make your students think. Jangan didikte satu ini penyelesaian yang benar, ini seperti ini. Saya kadang-kadang kaget melihat, bukan ibu, tapi di Universitas Indonesia lain, kadang-kadang saya kaget cara pendidikannya. Tapi harus bikin apa pikiran Anda, apa pendapat Anda, dan bukan pendapat saya harus memberi alasan. Saya tidak ingin dengar pendapat tanpa ada alasannya. Tapi mahasiswa harus belajar memberi alasan yang baik untuk mendukung satu pendapat atau satu solusi. Jadi kalau ini semuanya dilaksanakan itu memang hukum Indonesia akan bagus sekali, lebih bagus dari Belanda. Terima kasih.
Terima kasih Adriaan untuk presentasi reflektif yang sangat menarik. Saya sadar ada keterbatasan waktu. Sweta di belakang dari tadi udah. Tapi masih boleh nego 5 menit diskusi, tanya jawab. 2. Masih boleh Sweta?
Untuk pertanyaan 5 menit boleh?
Gimana Pak Marek? Oke, 2 ya? Oke, kita akan ambil 2 pertanyaan. Tadi
satu Pak Toko, satu lagi, sebenarnya ada banyak tangan yang angkat, tapi maaf ini berdasarkan kecepatan. Ya mungkin Bapak ya.
Masuk?
Ya.
Oke, makasih. Saya terima kasih untuk thank you very much Prof Joanne untuk very interesting lecture yang sebelumnya before Adriaan ya. Terima kasih Profesor Adriaan untuk penjelasan sangat menarik ya. Saya ada dua komen atau dua yang ingin saya sampaikan. Pertama adalah tadi dari contoh kasus yang Prof Adriaan sampaikan mengenai mana lebih penting ya, apakah teks yang tertulis di situ yang dalam kasus contoh pakaian hakim tadi ataukah intensi atau tujuan dari hukum itu. Mungkin kalau bisa saya tafsirkan itu lebih dekat ke aliran subjektif ya sekarang, karena dalam hukum pidana itu ada perdebatan antara aliran objektif dan aliran subjektif ya. Dalam kasus bukan pakaian ini, yang kasus teroris tadi ya, berarti ketika dia menggunakan bahan-bahan yang sebetulnya tidak bisa digunakan untuk bom, kalau di kajian hukum pidana itu kan berarti tidak mungkin delik itu selesai, tindak pidana itu tidak mungkin selesai ya. Jadi kalau di rancangan KUHP Indonesia sekarang itu mungkin dipidana tapi hukumannya dikurangi gitu ya di rancangan. Itu satu. Apakah memang lebih dekat ke aliran subjektif di Belanda ya. Yang kedua adalah mengenai dari penggunaan berbagai interpretasi tadi ya. Itu kan memang semua bisa digunakan dan itu kita berikan Prof Adriaan di dalam perkuliahan, kita berikan semua berbagai macam interpretasi tadi. Kadang-kadang di dalam praktek itu baru timbul pertanyaan mana yang lebih diutamakan untuk digunakan. Nah, saya ingin tanya gimana di Belanda saat ini di dalam putusan-putusan pengadilan lebih cenderung mana hakim. Satu lagi mungkin singkat saja. Mohon maaf ya. Satu lagi singkat mengenai apa sih sejarah hukum sebetulnya, sejarah legal education ya. Jadi kalau tadi diceritakan oleh Prof Adriaan ketika Reho School, tapi saya tuh sebenarnya penasaran, sedang membuat buku Prof Adriaan mengenai sejarah Fakultas Hukum UI. Sekarang sedang disusun, belum selesai. Tapi saya ingin mungkin Prof Adriaan ada sumber yang lebih tegas bagaimana sejarahnya dari Reho School, kemudian karena ada masuk di notes Universitas Indonesia dan seterusnya sampai ke Fakultas Hukum UI, itu ada linknya ya, bisa saya mengatakan atau kita mengatakan bahwa memang FHUI itu adalah penerus dari Reho School itu. Nah, itu tiga itu ya. Makasih Prof.
Thank you very much, Profesor Adriaan. My name is Alfian. Kami tadi melihat salah satu slide Bapak Profesor yang mengatakan bahwa ada tujuan hukum itu ada tiga, di situ dijelaskan. Satu adalah kepastian hukum, keadilan, dan kemanfaatan. Di satu sisi mungkin kalau kita melihat perjalanan hukum Indonesia dari zaman Hindia sampai sekarang, boleh dikata kami mengatakan tadi kesimpulannya Prof bahwa seakan-akan kita agak ketinggalan. Mohon maaf. Namun ketika kita melihat piramid ini, kita boleh mengatakan di mana kita bisa melihat sehingga hukum Indonesia ketinggalan. Apakah kita melihat di keadilannya, atau kita melihat kemanfaatannya, atau kita melihat kepastian hukumannya? Nah, saya pernah bertanya kepada salah satu pejabat yang dari Belanda bahwa ada satu praktek hukum yang dilaksanakan pada waktu zaman Hindia Belanda, kalau tidak salah namanya TZMKO, Territorial and Maritime Criminal Ordonancy. Kami menanyakan ke pejabat yang dari Belanda waktu kunjungan ke Indonesia, dia mengatakan bahwa praktek itu sudah tidak ada di Belanda, sementara di Indonesia kami masih melaksanakan itu. Berarti kan kami melestarikan apa yang sudah diberikan oleh yang jadi pertanyaan ini kami kaitkan dengan ini tadi, kita mau lihat di mana, karena memang begitu pesat perkembangan dunia atau masyarakat. Kami merasa di negara kami itu sangat cepat perkembangan masyarakat. Bahkan baik pemerintah ataupun pengambil keputusan atau yudikatif ataupun eksekutif, legislatif mungkin agak kebingungan melihat perkembangan, sehingga boleh dikata ketika kita harus melihat ini secara keseluruhan, kita harus bahas satu persatu. Bagaimana konsep yang mungkin Profesor bisa berikan kepada kami sebagai sharing untuk kami bisa menjadi dasar atau basic yang sangat bagus dalam rangka untuk kita mengembangkan sistem yang lebih luas. Kalau kami melihat konsep-konsep ajaran-ajaran, contoh-contoh kasus yang sudah pernah kami belajar pada waktu kami S1, ya mungkin saja masih tetap sama. Demikian, terima kasih.
Oke. Mendengar Prof. Makasih. Kalau yang pertama, kalau itu memang ada banyak perdebatan di Belanda mengenai unsur-unsur subjektif yang dimasukkan di dalam undang-undang itu. Tapi itu memang ya itu satu diskusi politis dan itu memang hasilnya seperti ini. Dan itu hukumannya memang kurang berat kalau kasus seperti itu. Ya, jadi itu memang tidak seperti bayangkan kalau itu memang bahan-bahan yang benar, itu pasti dia dihukum lebih berat daripada dari sekarang. Kalau mengenai metode hukum, nah itu berhubungan juga dengan pertanyaan Bapak. Sebetulnya metode hukum saya sudah tahu itu, tapi mengajar metode hukum hanya bisa dengan mengajar bagaimana bisa diterapkan. Jadi kalau saya sekarang memberi contoh seperti ini, ya itu barangkali menarik buat siapa yang belum tahu, tapi ya pada umumnya itu memang kami hanya bisa belajar itu dari bagaimana hakim menerapkan itu, dari contoh-contohnya kita bisa belajar, tapi kemudian kita harus memang menggunakan metode sendiri. Dan itu bisa saja bahwa misalnya dalam satu eksamen, jadi ujian, itu sebetulnya dua jawaban yang berbeda, kedua-duanya bisa baik kalau alasan yang diberi. Tapi itu misalnya menjadi salah satu masalah di Indonesia, banyak hakim tidak memberi alasan yang jelas. Kalau gitu, itu menjadi lebih susah lagi buat pakar hukum, karena mereka kemudian harus memang menjelaskan, harus menginterpretasi, interpretasi alasan-alasan yang barangkali dipikirkan oleh hakim, oleh sistemnya. Nah, itu memang saya lihat ada memang masalah-masalah seperti itu, tapi saya kira itu bisa dihadapi kalau kita memang dari hari pertama mulai dengan menyelesaikan kasus, jadi caranya seperti itu. Nah, kalau secara ya saya itu benar, itu memang jelas itu ada hubungan langsung, terutama yang tahun 50-an itu memang pendidikan masih sama dengan zaman sebelum Perang Dunia Kedua. Yang masalahnya itu memang pada akhir tahun 50-an, dan itu memang karena tekanan politis waktu itu, dan karena ya sengketa di dalam tubuh UI Fakultas Hukumnya, itu memang waktu itu memang jadi tingkat yang mulai turun. Jadi saya bisa memulai, saya tidak punya waktu untuk memberi contoh, tapi memang dari diskusi sama Pak Kosalsik, Pak Bensyong, Ibu Bedner Bulan, Pak Boboto, semuanya memang menjelaskan seperti itu, bahwa ada perkembangan yang tidak baik, dan itu terutamanya karena tekanan politik dan itu kekurangan dana juga. Jadi saya kembali ke Bapak, ini saya kira itu perkembangan sekarang ini di sistem hukum Indonesia sangat-sangat positif pada umumnya. Ada Mahkamah Konstitusi, sekarang ada publikasi putusan. Jadi perkembangan luar biasa. Itu baru 20 tahun Soeharto harus turun jabatannya. Jadi kita jangan harus terlalu optimis. Itu memang memakan waktu banyak sekali. Jangan terlalu pesimis. Tapi jadi yang sudah yang tercapai sudah bagus saya kira. Tapi itu saya kira sekarang ada waktu untuk melangkah maju lagi. Dan saya kira itu memang ya tidak ada salah satu solusi. Tapi saya kira yang kuncinya adalah untuk menggunakan sumber hukum yang sudah bisa diakses sekarang ini untuk karena sekarang ini perkembangan hukum hanya datang dari legislator, ya, jadi semuanya dari sana, bukan dari hakim, dari kekuasaan kehakiman, dan bukan dari kalangan universitas atau cabang. Nah itu harus berubah, saya kira. Karena itu memang dari legislatif itu bahaya dan mereka tidak bisa semuanya. Jadi harus ada kesimpulan. Dan mengenai, setengah menit. Legal certainty, utility justice, saya kira itu memang yang sangat utility yang sangat diperhatikan di Indonesia. Tapi utility itu kadang-kadang juga manfaat pribadi, bukan manfaat umum. Tapi yang penting itu memang kepastian hukum yang harus didorong terus dengan dan keadilan itu memang dalam kasus tertentu juga. Jadi kita, dan itu memang adalah walking on a tightrope. Itu dalam, tapi kalau hasilnya dari walking on the tightrope, dari pertimbangan itu memang jelas dan diletakkan atau ditaruhkan di dalam satu putusan pengadilan, kemudian itu menjadi pedoman buat kasus-kasus yang nanti aja. Dan saya kira itu, saya tidak tahu contoh lain yang mendorong perkembangan seperti itu.
Ya, sayangnya waktunya sangat terbatas karena mereka harus pergi ke tempat yang lain, mereka masih harus ke Erasmus. Profesor van der Leun dan Adriaan harus ikut jauh bagi presentasi. We hope to see you all again here at UI, Universitas Indonesia, soon, we hope. And enjoy the evening at Erasmus. Pak Topo will be sent a souvenir for Adriaan. Thank you so much.
Who will have first of all, I should say that I'm really happy to be the moderator of this session. This panel session will talk about the English Talk program in the Netherlands. The topic is really close to my experience because I recently graduated in the English Talk program in the Netherlands earlier this year. And then what is the common question that people ask to me is how could you cope with the situation there? How could you cope with the cultural shock or the language gap, so called, and how could you communicate well with the society? Are you speaking? Do you speak Dutch? Do you have a family or relative there, or how come you cope with that kind of issues to studies abroad in the Netherlands? First thing that I should let you know that I'm not speaking Dutch, not words, not words. And then my experience when I studied in the Netherlands was the most exciting experience. I didn't feel any culture shock at all because I feel like I'm part of my friends. That is mostly are the international students. So today we are pleased to welcome Ms. Annette van Sandwich. She's the head office for international education in the Leiden University, and Mr. Henk Holshoff. He's the lecturer at the Department of Child Law in the Leiden University. And at the end of the session, we will have a little presentation from the Leiden Indonesian Representative Office from Ibu Rosa Damayanti. So, first presentation, I will give you time. Anna.
Thank you very much. I'm also very happy to hear that you had a pleasant experience in the Netherlands. I'm always happy when students are happy, and I think basically all the international students that come to the Netherlands, they will have an excellent time. Today I would like to tell you a little bit more about the Netherlands, because I was wondering who of you have been to the Netherlands before? 1, 2. Oh, yeah, that doesn't count, does it? No, so I'd like to tell you a little bit more about the Netherlands, tell you a little bit more about Leiden University in general, and then I will narrow it down to Leiden Law School and the law programs we have to offer. The reason why I'm here, of course, is that UE and Leiden University or Leiden Law School have had a long-standing relationship, and part of that relationship is the exchange program that we have. So we exchange students every year, but we also receive many students in our master's program. So this is also why we're here, and so I'll also tell about the exchange program that we have. I will tell something after the programs. I will tell something about the admission requirements, about the tuition fees, scholarships, so some practical information, and of course I will ask Professor Henk, shall I call you that, to tell a little bit more about the International Children's Rights Program. Because, well, he teaches in the program, so he knows a lot more than I do. And after that, there will be time to ask questions, of course. So, yeah. So, the Netherlands. We're a small country, and right now it looks even very small because I cannot read all the names, but we're a very small country in the northwestern part of Europe. And to give you an idea what the Netherlands look like, I will briefly go through all the different parts. This is in Groningen, the north of the Netherlands, which is actually also a university town. This is Friesland, also in the north of the Netherlands. Lots of water, as you can see, but we have a very good water management system. I will come back to that later on. This is where people go boating in the summertime when we have nice weather. So, north of the Netherlands. This is the province of Drenthe, which is a little bit more mid-east. These are actual ancient burial grounds. This is how people long away, long time ago, they buried the people like this, and they put rocks on top of it. It's still a little bit mysterious. This is Zwolle, Overijssel, also a nice city, with lots of history. Most of the cities in the Netherlands, they have a lot of history, and it's really nice. They're like museums, basically, if you walk around. This is Gelderland. This is where you are from, right? This is where Henk is from. Beautiful area, I would say. Less densely populated than the western part of the Netherlands. And as you can see with the heather, it's a beautiful area. I think many people like to go there for the weekend, to go walking, cycling. This is the latest addition to the Netherlands, the province of Flevoland, in the middle of the Netherlands, and I will come back to this province in a bit. Utrecht, in the middle of the Netherlands, with the Dam Tower. You can see on the right and the left hand side. You can actually climb all the way up to this tower. It's 110 meters high, I think. This is actually a very interesting picture. This is the province of Brabant in the middle, and what you see here is a castle, and a famous person was being held captive here. Do you know who the founder of international law is? Hugo Grotius, I heard his name. You got extra points. Well, he was being held captive here in, I think it was 1610. A religious dispute started in the Netherlands, and he got involved, actually politics got involved in this dispute. And Hugo Grotius, the founder of international law, got involved as well. But he didn't agree with the current ruler, so I think it was 1609 that he was put into jail, and the jail was his castle. And what I like about the story is, I really liked it as a kid. Of course, Hugo Grotius, being an academic, he would order books every month to read, because he had to stay up to date with all the current affairs. And the books would arrive in a big book chest, so it was like a big case. And then at some point he started thinking, how can I escape this castle? Because he had been there for some time already. So 2 years after he was being held captive in the castle, he fled in the book chest. So instead of sending books back for a new order of books, he was hiding in the book chest, and he fled the castle and escaped. So I like the story, so there's a lot of history here as well. I think you're familiar with this picture, maybe? The province of Limburg, exactly. In the south of the Netherlands, you see it's a little bit hilly. And this is the province of Zeeland in the southwest of the Netherlands, with a beautiful coastline. And I think many of you maybe have seen this picture. You've probably been to Amsterdam as well. Yes, this is the sign actually where everybody wants to take a picture. Although you didn't, and you have to be quick because there are all kinds of discussions going on that they want to remove this sign because it would be too individual, the I and Amsterdam. So it's still there, and I think it will remain there for a while, but it's under discussion. And then last but definitely not least, the province of South Holland with Leiden over here. This is what Leiden looks like in the summertime. So we have lots of canals, people are enjoying drinks outside, they go on a boat. I think sometimes they even have traffic jams in the summer on the water because it's so busy. But in the summertime, but also in the wintertime, Leiden is a very nice city. Well, I told you before, it's a very small country, especially if we compare it to Indonesia. Border lengths are like 450 kilometers, so really, really small. And I told you that it's a highly densely populated country. We have like 481 people per square kilometer. So especially on the western side of the Netherlands, there will be many people. What I really like about the Netherlands is that we have a very mixed community. We have around 190 different nationalities. So people come from all over the world and they live especially in the bigger cities. But if you go to cities like The Hague or Rotterdam or Amsterdam, you can basically buy food, go to restaurants from every country you can think of. And I can tell you there's also a large Indonesian community in the Netherlands. If you go to The Hague, for example, there's a large Indonesian community. You can buy real Indonesian food, I think. So, yeah. Also good to know, the Netherlands and Holland are actually, both actually usually when people ask me where are you from, I will say I'm from Holland. But the official name is the Netherlands, and it actually means low-lying country. Low-lying because we're low sea level. Holland refers to two provinces, so the North Holland province and the South Holland province. I showed you a picture with lots of water. In total, we have 4,000 kilometers of navigable lakes, canals, and rivers. So there is a lot of water in the Netherlands. There are also a lot of bicycles in the Netherlands. I think, well, here it says around 18 million bicycles. So there are even more bicycles than people in the Netherlands. We have around 17 million people. And everybody uses this bicycle to get from one place to the other, especially in the bigger cities. The city centers are, well, cars are banned over there. They're not allowed to drive into the city center. So a bicycle is a perfect way of transportation. And apparently, according to a Rutgers University study, it's the safest in the Netherlands because we have special bicycle paths. Did you ride a bicycle when you were? You didn't? No? But that's because of the hills, of course. Well, this is, I think, a funny story. If you see more of the Netherlands, you know that we're a very flat country. And this is actually, this picture shows the highest point in the Netherlands. It's called the Waalserberg, the Waalser Mountain. And it's 323 meters high. So it's really, really small. Although, and as I mentioned, the rest of the nation is as flat as a pancake. This is what I told you about the water management we have. 25% of the Netherlands is situated below sea level. But we have a very good way of keeping the water out by systems like these. These are the delta works in New Zealand. And it functions very well. So when you come to the Netherlands, you will be safe. And I told you about the latest addition to the Netherlands, the province of Flevoland in the middle of the Netherlands. Before 1986, there used to be water. It used to be the South Sea. And now it's turned into a province and people actually live and work there. So quite impressive. Also an interesting fact, the Netherlands were one of the founding fathers of the European Union, which of course is very important. Maastricht also plays a very important role, but very important thing. And this is what the Netherlands look like on the King's birthday. Everybody will dress up in orange. Most of the people will go to Amsterdam to party, but I think you probably also celebrated King's Day, right? Yeah. What happens before our current king, King Willem-Alexander, got king? His mother always celebrated her birthday on the 30th of April. And apparently in some guidebooks, it still says, if you have it on the guidebook, people will think that the celebration of the king's or queen's birthday is on the 30th of April. So sometimes it happens that people arrive in the Netherlands on the 29th or 30th and they think they will be celebrating, and it's already gone. This is, I like this, it's a funny picture, but I wanted to show you, we were talking about languages before. Of course, our first language is Dutch, but around 87% of the Dutch people speak English at some level. So if you go to a supermarket or to the library or on a bus, people will speak English. So when you come to the Netherlands, there's no need to learn Dutch. Although we always advise students, if they want to stay in the Netherlands, find a job, then it would be very wise to start studying Dutch, because at some work level, some places in the workplace, you have to speak Dutch. So I like this picture because, of course, we say that Dutch is the best language. German is like overcomplicated Dutch. German and Dutch are actually quite similar. Of course, the Russians, they have mirror letters. The Italians, they speak like this. But this is a nice, of course, we have many languages in Europe, and Dutch is actually a very small language compared to the other languages. Well, a little bit more about Leiden and Leiden University. We are the oldest university in the Netherlands. We date back to 1575, so next year we will have our 444th birthday. We're very proud of that. In total, we have 7 faculties. We don't have technical programs or economics, but basically everything else. We have a faculty of medicine, a faculty of law, archaeology, humanities, social sciences, and global affairs and governance. So very widespread of programs. And the Leiden University is not only located in Leiden, but also in The Hague since a couple of years. And of course, The Hague is a very important city. It's called the legal capital of the world because of all the international organizations and courts and institutions that are there. So for the law school, it's also very important to be in The Hague. So most of the programs for law are still offered in Leiden, but for example, public international law is also being taught in The Hague, close to where the action is basically. Leiden is a very nice city. It's a very small city, especially if we compare it to Jakarta. I think we have around 15 million people here. Yes. Leiden has 120,000 people, so it's much smaller. But I think for international students, it's really convenient because you get to know the city quite soon. And because all the university buildings are located in the city center, and you walk from one building to the other, you will always run into people you know, and you're easily familiar with your new surroundings. Another nice thing about Leiden as well is it's a rather safe city because it's not so big. And what I really like, it's a beautiful city. It's very historical with beautiful canals, beautiful houses, and well, on top of it all, it's a real university town. 30% of the population is a student, so there are also many facilities for students. The Hague, well, for us, it's like I think our dean mentioned it this morning as well, or this afternoon. It's a totally different city, but I think for you, you would say it's like part of Jakarta. Traveling from Leiden to The Hague by train is only 12 train minutes, so it's really nearby, but they're two different cities. So, The Hague is a little bit bigger, 525,000 people. Located, well, we have beautiful sea sites, Scheveningen, Kijk, really nice sea areas, and of course, it's a very international city. It's you can tell. I think usually Amsterdam attracts many international people because these people are tourists. The Hague has international people because they work for the international organizations, and that gives it a really nice atmosphere. Well, the motto of our university, I think it was mentioned before today, is the bastion of liberty, and it means that you have the freedom to discuss whatever you like to discuss as long as you have a good, open discussion. So we welcome also, when we launch our exchange students or exchange program, we welcome students from every country. Even though you could say some countries are a little bit doubtful, or we'd like to have a very international classroom so people can go into discussion with each other, share each other's stories, hear each other's perspectives. So it's very important. Also, our university has very close ties to the Dutch family, the royal family. Our current king, Willem-Alexander, he studied history at Leiden University, but also his mother, Queen Beatrice, she also studied at Leiden University, so we have some famous alumni. But there are more alumni. For example, Albert Einstein used to be a professor at Leiden University. Of course, not a law professor, but a science professor. And there was actually a funny story. Apparently, Albert Einstein sent in his application letter to work at Leiden University. And at first, he was refused. They thought Einstein was not very clever enough yet, or didn't have very good ideas yet. So they said, well, maybe not now. Luckily, he decided to come after all. Every summer, Einstein would come to teach at Leiden University, so we're happy we didn't send him away at all. Next to Einstein, we also have former US President Quincy Adams. We have our current Prime Minister, Mark Rutte, also studied at Leiden University. And are you familiar with Armin van Buuren? You are, that's good. Sometimes when I give a presentation, I say, yeah, world famous DJ, Armin van Buuren, and everybody's like, I don't know him. It's good you know, and he's actually a law alumni. Yeah, he graduated from law school, but well, he decided to go for his DJing career. So, but we still have ties with him, and he sometimes helps the law school as well. Well, I'd like to show you a little movie now about Leiden Law School, so you get an idea of what it looks like and what we offer. like the movie. I will continue with my presentation. Leiden Law School, as you can see in the movie, is located in various buildings. The main building is the building on the left-hand side. It's the Kamerling Honors building. It's where most law students will be, but also the building on the right-hand side, on the top row. It's actually an old observatory. It still functions as an observatory, and we have small-scale classes in there. And the two pictures below, you see the campus of The Hague and our academy building, where all the formal occasions take place. Our law school is a rather big law school. We have around 5,200 master and bachelor students in total. We offer bachelor programs in Dutch because it makes sense to learn about Dutch law in Dutch, I think. And, well, it's not very interesting for international students. But we also offer many master's programs in English next to Dutch law programs as well. And I will tell you a little bit more about that later on. This is how our education system looks like. I think it's a little bit different from Indonesia. When students want to become a lawyer in the Netherlands, they will have to do a 3-year bachelor program and a 1-year master's program. So only after those 3+1, they can become a lawyer. After that, we have the possibility of doing advanced master's programs. These are more intensive programs. And of course, we also offer a PhD track, which is 4 years in the Netherlands. Next to this, you can also see the pink box next to the bachelor program. We have the Leiden law courses. These are English law courses on bachelor's level, and they are about a large variety of different topics, and I will tell a little bit later about that. Leiden Law School, internationally speaking, we have partnerships with universities all around the world. Of course, I started my presentation by saying that we have a cooperation with UE, but we also work together with Oxford University, with Peking University in China, with Sciences Po in France, and for example with UCLA. And these are just a few. We have so many exchange agreements. Every year we receive about 200 exchange students coming to Leiden Law School to take courses. So we have a very large exchange program. And students from OE can also come to Leiden for an exchange, so for a semester. In total, we receive about 500 to 600 international students per year, and this number is actually growing and growing, and I think it might even be more already this year. The law school also participates in many international networks, such as the League of European Research Universities, but also SARFA, the Koimar Group. We are active in many of these programs. We offer various summer programs. We have a special center, the Grootsia Center, who organizes many summer programs in the summertime. And my office organizes the Columbia Summer Program every other summer. We do this together with the University of Amsterdam. They will be next year it will be in Amsterdam. But we organize a 4-week summer program on American law. And of course, as long as we're high in the rankings, I always mention that in my PowerPoint presentation. We currently rank number 27 in the Times Higher Education ranking and number 32 in the QS Law ranking. We're very proud of that. Of course, we also know that rankings are a little bit subjective, so it's always, you always have to think if this is really the correct ranking, but we think it does give a good indication of what we can do at Leiden Law School with regards to education and research. The exchange program, as I mentioned before, because we have this agreement with UE, students can come to Leiden for a semester. They have to have completed 2 years of law studies here in Jakarta before they can come to Leiden as an exchange student. There's a possibility of coming for a semester or sometimes a year, but most students prefer a semester. I think it usually better fits in the curriculum here in Jakarta. At the end of your program, of course, you will not get an official diploma, but you will get a transcript with all the courses you took and the grades you received. And the nice thing about the exchange program, I think, is that you will be in the class with students from all over the world. We work with all European countries, but we also work with Lebanon, with Israel, with China, with the US, with Chile, with Brazil. So you will be in a very international classroom. And I think it's good to learn about different legal perspectives, and also it's good for students to learn in a new educational environment, of course. Courses that are part of the exchange program, for example, we offer, I think, around 20 English courses per semester. But we offer, for example, like aerospace law, we have a moot court in public international law, We have a program on human rights law, introduction to children's rights, labor law, crime and migration. Oh, our dean talked about this earlier on. So we have a large choice of courses to choose from. Then for our master's programs, we have an even wider choice, I think. We have two options. We have programs that are called the regular master's programs. These programs are also part of the Dutch curriculum, so if a student wants to become a lawyer, the 3+1, these are the one programs. They're offered in English. We have a program on European law, a program on public international law and criminal justice. And with these programs, you will be in the class together with Dutch students as well. I would say like 50% or 60% would be international students and the other percentage would be Dutch. So you are in a very mixed class. And they're all one-year programs. So if you do well, if you work hard, you can complete your LLM degree in 1 year. All programs consist of coursework, so courses in various topics, and you end your year with a thesis. So thesis, your research thing is an important part of your program as well. And I forgot to mention, criminal justice is a small exception. It doesn't give you an LLM degree, but you will get a Master of Science degree because, of course, it's a combination of law and social sciences. Then we have what we call the advanced master's programs. For these programs, well, they're very specialized. I will show you the names of all programs. They attract students from all over the world. Usually there are no Dutch students in the class because they will already have completed their regular master's program. But students here, they come from all different countries. They come from different backgrounds. Sometimes some students have been lawyer for a couple of years and they want to specialize in a certain area. We've had ambassadors in our program who wanted to specialize in a certain area. But the programs are also open to students who graduated and who already got some work experience, because some work experience is required or highly recommended for these programs. The teaching methods, because these groups are much smaller than the regular master's program, the teaching method is what we call the Socratic teaching method. It's very interactive. Maybe you want to tell a little bit about that later on as well, how you do the courses. But you're really expected to engage in discussions and not to just only listen to the professor, but really be active in the classroom. And I think it's, if you want to become a lawyer or be active in the legal field, that's a really good skill to learn. The groups usually are around 30 to 35 students, but some of our programs, such as public international law, is extremely popular, so sometimes the groups are a little bit larger than. But we try to keep the groups small so we have this real community. After a year, all the students in your class will be like your family, basically. I think that happened with children's rights last year as well, but I think this year too. With these programs, what I like is, of course, you will go to class to have courses, but there will also be many field trips and excursions. And most of the programs have like a couple of days trip to a European country to see actually, to go to the organizations that are dealt with in class and now to see them in real life action. Maybe you want to tell them a little bit more about international human rights. So it's, of course, it's a lot of theory, but it's also combined with practice, and I think that's an excellent combination. As I mentioned, very specialized fields, air and space law. I think Leiden Law School is one of the 3 universities where you can actually follow courses in this field. It's a very nice program, very, as I said, very specialized. You can also actually choose whether you want to focus on air law or on space law. So very nice. We have a program on European and international business law. This is always a very popular program as well. I think business and commerce always attracts a lot of students. We have a program on European and international human rights law, so you will get to learn about human rights law from different perspectives. Then we have a program on international children's rights. So maybe this is your cue to tell a little bit more about that program.
Yeah. Hi, good afternoon. I feel sorry for you. I mean, it's quarter past 4 and you're still here in the room. I think that's very respectable. I'm very happy that you're still here. And I'm trying to make it a bit interactive because you were bombarded with information by Annette, right? And I'm going to check. I'm going to check whether you actually listen carefully to her. So, which was that city up in the north with the Martini Tower?
Groningen.
Groningen, yes. Yeah, okay, very good. That was a good impression. Anyway, I understand that many of you study law and gender, right? Who's studying law and gender? Well, not all of you. Okay. Who has ever considered studying human rights law? Okay, I think I've got about 10 minutes, one person? Oh, okay. Yeah, you of course, yeah, I know that. Okay. I think I've got about 10 minutes to convince you that you should be studying children's rights law, right? Okay. What do you think? Where can you study international children's rights? Where can you get a legal degree on international children's rights? Only one city in the world. Yeah. I know I'm a bit boastful, right? I'm boasting about the course, but it's the only place where you can actually get an LLM, a legal degree on international children's rights. I am telling you, you can study after you've had a few years of work experience. That was actually me. I was working for 15 years and I thought, I want that legal degree. And my interest is women's rights and children's rights. Now, women's rights, there's no legal degree on women's rights in the Netherlands, so I decided, okay, children's rights. So I said goodbye to my employer and I started studying. And I found myself between students aged 19, 21, and I was the oldest one, obviously. But it was a fantastic experience. I will try to convince you through, I think, 4 or 5 arguments why I believe international children's rights law in Leiden makes sense. Can I put the presentation on, please? Yeah. And I've already told you what we have to offer, right, in Leiden when it comes to children's rights or children's rights law. I'm going to focus on this one, right? On this Master of Law on top, Advanced Studies in International Children's Rights. Next one, please. I think what really surprised me when I started this course was staff. We had not academics; they were rock stars. I thought. I was looking on information on international children's rights. I was googling, and I entered international children's rights law. And when you press enter, all staff from Leiden University come out. For instance, Ton Liefhard. That name may not ring a bell with you, but once you're part and parcel of the international children's rights community, he's all over the place. I mean, wherever I go, I went here to Jakarta, my first time, and hey, can you send my regards to Ton? Now that's fantastic. I mean, I've been to all the place, everybody knows them. We have another lady, her name is Julia Sloth-Nielsen. She is high-profile human rights and children's rights expert in Africa. Whoever you talk to on children in Zambia or South Africa or Ethiopia, they always mention Julia Sloth-Nielsen. She's one of the teachers at the faculty, and that's good. These are people, Tom Liefhard too, who are in not only academics, they're in daily practice, in the implementation of children's rights. That's what I like about it. I didn't simply want to learn and listen to what the teacher has to say, but I wanted to pick up skills which I personally needed for my work. And I got it there. I think Annette already mentioned it. You're not just reading books, writing exams, off you go. No, in Leiden the groups are small. I was actually studying with 13 people. So we had, I think we had more teachers than students when we started. That's very good, since you get 1-to-1 almost guidance as you go along. Since Leiden University takes its courses very seriously, so you have to work hard. This is not simply a matter of taking a plane, land, study and depart again. No, you have to work hard. I was working, well, I wouldn't exaggerate that, perhaps 11-12 hours a day during 11 months to get that degree. But it was worth it, since you pick up legal skills. I spoke to many students from other countries and I was asking them, is it the same here as it is in your place? A lady from the UK was saying, well, for a start, I find myself amongst 265 students. We're in a big hall and we listen from a distance to what the teacher has to say. and off we go. In this course in the Netherlands, it's really personal guidance. I mean, I'm not a lawyer, and I started this course on the basis of my work experience. I worked on human rights for a long time for United Nations and for Amnesty International, and I wanted to have that degree. And I didn't really have the purely legal skills. Well, you got guidance. They give you assignments, and they're standing next to you to show you how to do it. How do you put together a legal note? I had no clue how you did that. But after 10 months, that's very quickly, I knew how to go about it. So now, after not even 1 year, I can analyze any legislation from whatever country through the prism of children's rights. And I think that's an achievement. I found that. All credits to Leiden University when I was studying there. Again, I'm a bit boastful of my university, but I was there as a student and I'm here now as a lecturer. So I've seen it from both sides. And that's precisely what students like. This personal guidance, right? Which is a bit unlike what you get in many other countries. Not sure about here, but I'm just trying to share some of the experiences of other students. So I mentioned already the staff and guidance. Well, the third, the network. Obviously, when you study, you're also thinking about what you're going to do next. And as she mentioned already, you can do a PhD. Fantastic opportunity. We are waiting for you if you want to do a PhD on any of the legal degrees on offer in Leiden University. But the network that you get there is fantastic. You get in touch with many organizations, potential employers for whom you perhaps would like to work. That's good, since these people I mentioned, Julia and Tom and many others, they're extremely networked. They know everybody in the world of human rights and children's rights. So for instance, I was very interested in social protection. I'm a development guy, so I thought the right to social protection is very interesting. Before I knew it, I was in touch with many African officers of UNICEF, and I talked about social protection. And I got all these contacts through staff at Leiden University. So you become very much networked. Where's my wallet? And mind you, this is an advanced degree I'm on about. An advanced degree is slightly different from a regular degree. It's advanced particularly for one reason, because it's very much oriented towards practice. You pick up skills that you will need in your profession later on. Again, what other students told me is, I picked up these skills when I started my first job. That's another way of doing it. Well, I'd say, well, why not do it straight away? As you study, that's easier, and you have a better chance of getting that good job. Since I recall the 13 students which I mentioned, many of them are already working in a field of children's rights in the countries where they come from. Just one example, one of my fellow students, she's now working for the Office High Commissioner for Refugees in Ecuador. She is from Latin America, and only a few months after she graduated, she found that job. Fantastic, I'd say. Why? Because she could demonstrate that she had not only like intelligence, academic way of thinking, but also the skills to work in the field. Because she had had many assignments which had one way or another to do with, in this case, refugees and migrants. Okay, I already told you practice-oriented. Yeah, I think that's one of the added values of studying at Leiden University. It's very catered towards your needs, and you can actually make of your course what you want. Again, I had a very crystal clear action path in my mind when I started, and I focused really on social protection in Africa. And by the end of my 11 months, I actually became more or less a specialist. And that's, if you have, for instance, an interest in migration law, you can focus on child rights and migration. If you're interested in, for instance, economic rights, you can focus on the economic rights of children. And whatever you're looking for, there's always a specialist waiting for you at the faculty. Okay, I just told you you're being bombarded with information, and I'm bombarding you with information again. Anyway, next one please. I'm not sure whether if you want to learn more about the masters that we have, amongst which on the international children's rights and also on European and international human rights, in addition to all the others, check out this website and spread the message. There's information for you here waiting. Just grab one of these leaflets, and if you feel that in your network or in your circle of friends there might be people interested in studying in the Netherlands at Leiden University, be it one of the courses I mentioned or one of the others, let us know. It's Annette, did you tell about finances actually?
No, I will continue, but I think
You'll
everybody
continue.
will want to study children's rights now.
Oh, so yeah. This is just one example, right? I mean, this is not to the detriment of all the other courses, but again, I did the course myself and I was very enthusiastic about it, but I'm quite sure that also counts for all the other courses on offer. And thank you for your attention, and I think Annette will now talk also business, right? And other issues. Yeah.
Well, I think, do I need to continue with the list of programs we have to offer, or shall everybody, shall we shine on for international children's rights? No, we have other nice courses as well. We have a program on international civil and commercial law, a very popular program currently on law and digital technologies. Of course, this is a very current affairs topic, so a very, very good program. But we also offer a program on law and finance, and actually this program is open to both law students and students with an economics background. And so it's a very interesting combination. Then we offer a public international law program with 2 specializations. You can either specialize in international criminal law or in peace, justice and development. So you can choose your own track within the program. As of next year, September, we will also offer a program on global and European labor law. So this will be a new addition to the number of programs we already offer. And this September, a new program started as well, a program on international dispute settlement and arbitration. And I think this will be a very popular program. It already started with a very nice number of students. So as you can see, we have a large variety to choose from. And for you, I have the website, the website that Henk mentioned, but I will have it in one of my slides later on as well. For every program on the website, you can find information about the program itself. You will have a link to our e-prospectus where you see all the courses and where you also see the course descriptions for the courses, literature that's being used, way of assessment. So you will get all information you need, and should you be doubting between 2 programs, you can easily make a decision based on that information. I think it will give you a very clear picture of what to expect. This is very small. I wanted to show you an example of what a course schedule looks like when you do one of the advanced master's programs. Sometimes, I don't know how it's here, but some students expect that they will have class every day. This is not always the case, because you will also need time to prepare for presentations, to do reading, etc. So the colored boxes are the days that you will have classes. The black box is actually a special day in Leiden. It's the 3rd of October. It's when we celebrate the relief of Leiden, so it's always a day off for everybody. But as you can see, you will have courses like 2 or 3 times per week, and the rest of the week, well, you will be studying, preparing. And of course, sometimes we also during the weekends, for example, go traveling, because when you're in Leiden, you're in a very nice location and you can easily travel into every direction, not only in the Netherlands, but also within Europe. So we know that students will go on trips themselves as well, and that's good, I think. The entry requirements. For the exchange program that I mentioned before, as I mentioned, it's you have to have studied for a law for at least 2 years in order to be admitted. We require a GPA of around 3.2, so that's the average, and of course we require English language proficiency. TOEFL of 90 or it's wrong. TOEFL 90 or IELTS 6.5. And that's basically it. If you want to become an exchange student, you should contact the international office here and show them your interest, and they will have their own procedure to be admitted as an exchange student. Maybe you know more about this as well, I think. So yeah, she can tell you a little bit more about that as well. But it's very simple, and there are deadlines to adhere to. But going on an exchange, the nice thing about going on an exchange is that you don't have to pay tuition fee. You will still pay your tuition fee here in Jakarta. you don't need to pay in Leiden, so that's a positive thing, I think. So these are the requirements for exchange. Then, if you want to apply for one of our master's programs, one of the most important requirement, of course, is that you have a bachelor degree in law from a leading university, so from a good university. For the regular master's programs, we require a GPA between 3 and 4. And for the advanced master's programs, usually around 3.5. So this is to give you an idea of what we expect of you. Of course, here we also require English language proficiency, a little bit higher than for the exchange programs. Of course, law is about language as well, so it's really important that you speak and write and listen very well in English. So the scores for the advanced, for the master's programs are IELTS 7 and TOEFL of 100. And we also require minimum DAT scores for TOEFL 20 and for IELTS 6, so to give you an idea. What is also very, very important if you want to apply for one of our programs is your motivation letter. You really have to explain to us why you would like to study this particular program, what you think you can add to the program, maybe based on your previous experience, what you hope to learn from the program, and you really have to be careful. I know students, when they apply with Leiden University, they can apply up to 3 programs, and sometimes we get these very generic motivation letters, and we can tell, okay, this is somebody who's applying for commercial law, children's rights, and air and space law. And that doesn't work. We really want to show that you're really dedicated towards the topic and the subject. And so it's really important. You don't have to make like a very fantastic story, but you really have to show your interest, and that's the most important thing. Next to this, what's also important are the recommendation letters. We require one academic recommendation letter, and the other one can be from an employer or from another professor, for example. And this is also sometimes students ask me questions like, does it have to be a very famous professor that has to write the recommendation letter? And what we usually say, of course, if you can find a famous professor who knows you very well, then please ask him or her to write the letter. But if it's a famous professor who's had you in class together with like 200 other students and has no idea of who you are and just will write, yes, student X is a nice student, I had her in my class, kind regards, that doesn't mean anything to us. Then it would be more helpful to have a professor that knows you really well and can provide us with a very good picture of who you are in the class. So so a famous professor is not always the most important thing. And as I mentioned before, for the advanced master's programs, some work experience is required. This can be an internship, but of course, sometimes, as I mentioned before, we also have lawyers who've been practicing for some years and they want to specialize in a certain area. So we ask you to submit a CV as well, so we can see what you did before. Then, in case you've done your TOEFL or your IELTS test and your score wasn't high enough to be admissible to Leiden Law School, we offer the option of doing a pre-sessional English course. It's a 4-week course in the month of August, just before the start of the program. And if you have an IELTS score of at least 6.5, then you can be admitted to this course. And we basically guarantee that by the end of the course, you will have a 7 for your IELTS score, and you can start with the program. It's actually, I think, a very nice start of the program as well. It's in the summertime in Leiden, and Leiden in the summer is really nice and beautiful. And next to having this intensive language course, we will also organize some social activities. So you will already get to know the city a little bit, your fellow students. So it's a nice start as well, but it's also a nice option if you, if your language score wasn't high enough to do this program. Then important information, application and deadlines. Most of our programs, they start in September only. Air and Space Law and our regular master's programs, they also start in February. But we usually advise students to start in September because this is the way our curriculum is built. This September is when everybody will start with the program. But there is an option for some to start, of course, in February. If you want to apply for a September program, the deadline is 1st of April. And we have, I will come back to that as well, we have a special scholarship at Leiden University. If you want to apply for that scholarship, then you have to apply before the 1st of March, so keep that deadline in mind. If you want to apply for a February intake program, the deadline is 15th of February, so we just have that. The application application system itself, it's a two-step system. The first step is studying. It's a Dutch national registration system. You enter your details in the system, and within a couple of days you will receive an email from Leiden University with your personal student number and with directions on how to complete your application in our own database. And this is of course where you will have to submit your grades, your motivation letter, your letter of recommendation, your language proficiency, etc. Usually, between submitting your application and receiving the outcome of the application, this will take about 4 to 6 weeks. So that's an indication of when you can expect to hear more about your application. Tuition fees and scholarships. Tuition fees in euros, every program is 17,500 euros per year, and I put the amount in Indonesian rupiah between let's see, 302,887,550,000 rupiah. It's a very small print. For living costs, to live in the Netherlands, and also if you have to apply for a visa, the immigration services require you to show proof of around, I think, 900 or 1,000 euros per month that you're able to spend when you come to live in the Netherlands. There is a possibility to work in the Netherlands, but it's limited, especially for non-EU students. It's a limited number of hours, and usually we also advise students to first start studying because, well, you have to get used to the new education system, to studying in a different language, and you have to see how things are going anyway. You could try, but sometimes, like I said, you may need to speak Dutch, or there might be some other factors, but sometimes students, did you find a job, or did you look for it? No. Oh yeah, that's better. Oh, you're going to come out? Oh, okay. Scholarships. Leiden University has its own scholarship program, the Leiden Excellence Scholarship Program. This year we have 330 advanced master students, and we were to award 13 of these scholarships. And the scholarships are 15,000 euros each, so you still need to pay like 2,000 euros, which is, well, a very nice amount compared to the 17,500. For this program, the most important thing is, again, a good motivation, and of course you have to be a good student. Really, well, we should think, okay, we want to have this student in our class, so that's basically the idea of how the program works. Then of course there's the student program. It's a program by the Dutch and Indonesian government, so it's also good to check it out. Do you favor the LPDP? Yeah, LPDP is another possibility to apply for scholarships. And I mentioned one website here on my slide. It's www.grantfinder.nl, and this is an online database. I think it's very convenient. You type in, I'm a student, I'm from Indonesia, I want to study law, and then you get an overview of the possibilities for scholarships in the Netherlands. So it's always worth trying, I think. Also keep in mind, if you want to apply for a scholarship, most of the scholarship providers will require an acceptance letter. So you don't want to wait until the last moment to apply with Leiden University, because then you may have missed the scholarship deadline. So if you know for sure you want to come, apply as soon as possible. Then, once you've been accepted, you will be in touch, of course, with our staff. They will prepare you, and they will help you with applying for Hausa or visa. We will start the year with an orientation week, so it's a very nice week to get to know the city, the people, the staff, the faculty. So it's, I think it's a really nice start. During the year, there are international student advisors, we have psychological, legal, and financial counselors, we even have a disability center. We also have a career services office, and they can help you with CV checks, with workshops on how to use LinkedIn, for example, to find a job, or other useful subjects. So there are many support services during the year, but I think, and I put a picture in my slide, my office, the Office for International Education we have a very dedicated staff. Every master's program has its own program coordinator, and once you apply with us, you will be in touch with this person before you come to Leiden. They will be your contact person when you're in Leiden, but also when you leave Leiden. You will still be in touch. I actually sent a picture of Henk and an alumni to the program coordinator for International Children's Rights yesterday, because they met, and it's like, oh, I take a picture. We stay in touch, and you really feel part. Well, you feel like you're at home when you're in Leiden Law School. It's the same for the exchange programs. You will have your own exchange coordinator drop you if you have any questions, etc. Then, if you want to reach out to us, we have a website. We are on Instagram, on Twitter, on LinkedIn, and my personal email address is below. You can send me an email if you have any questions. I can refer you to the right person to talk to, but I can also help you, of course. So feel free to send me an email if you have any questions about the program. As Henk mentioned, we have some information materials here, some specific information about the International Children's Rights Program, but also a general flyer about the programs that we offer at Leiden Law School in English, and a little bit about Leiden Law School as well. Now I'd like to give the floor to Rosa, because as another service, I think, Leiden University has its own office here in Jakarta, and I think they can be very helpful in deciding where to study, what to study, and when. So thank you. Rosa. Maybe the pointer? Or you just want to talk? Yeah.
Thank you, Annette. Thank you, Hank. Perkenalkan, nama saya Rosa. Saya perwakilan dari Leiden University yang ada di Indonesia. Jadi mulai tahun lalu, Leiden University membuka kantor perwakilan yang kantornya terletak di Kedutaan Belanda di Jalan Rasuna Said, Kavling S3. Nah, kami, saya bersama dengan Pak Marik Belen dan Zweta siap membantu teman-teman dan semuanya yang mungkin mau mencari informasi untuk S1, S2 maupun untuk S3. Kami bisa membantu untuk khususnya untuk S3 mungkin mencari profesor. Kami juga bisa membantu untuk memperkenalkan ke profesor yang mana yang mungkin bisa dituju. Seperti itu. Di sini ada flyer juga tentang kantor kami. Oke, nanti boleh diambil. Di sini ada alamat kantor kami dan juga kami menerima untuk online counseling dan juga boleh datang ke kantor selama hari kerja. Kami terbuka untuk umum yang mau tanya-tanya, silakan. Setiap jam 9 sampai jam 4 sore kantor kami terbuka untuk counseling, dan kami juga memberikan nomor WhatsApp untuk online counseling. Jadi buat teman-teman, buat semuanya yang mungkin mau tanya-tanya lebih lanjut tentang Leiden secara general dan Leiden untuk jurusan hukum, bisa langsung hubungin kami. Terima kasih. Thank you.
For the presentation. I will not reserve any more time because it's already interesting presentation and pretty much cover all the technical part of how can you register, how can you apply to the Leiden University, and the information about the educational system in Leiden and in the Netherlands in general. But is there any question from you guys? Probably the student from the bachelor, if you have any question about, if you are interested about the program, about the continuing program, your studies in the Leiden, please.
Leiden with this personal engagement, personal touch with the systems, and also you mentioned about the specific master program on law and digital technology. I kind of wonders how this personal touch was implemented, because I think in education system with this digital online learning course, the necessary to go e-learning or something like that. So in what sense, to what extent that Leiden still keep the principle of personal engagement with students? Thank you.
Well, actually law and digital technologies was founded because we already have a large e-law department, so we had some professors who were already into this topic. Even though it will become, I think this year they will have 35 students, and that's basically what we say a little bit the max. So I think in the coming years, It means that the selection will be a little bit stricter. We really want to keep the programs small because we feel that it's the best way for everybody to get the new knowledge. We can also do this because the advanced masters programs, they are not funded by the government. They are fully accredited, but we don't get money. That's why the tuition fee is higher than the fee for Dutch students is. But because we're not funded, we can make our own rules. And one of our rules is that we don't want to keep the programs, or we want to keep the programs small. If you go to one of the Dutch programs, they can be very large sometimes. So we really, like I said, I think this year 35, I think that will be the max. Sometimes maybe we'll have 36 or 37 if we have some real good students. But I think the selection will become stricter, will become more competitive. Yeah. You want to add something to this, or?
Does that answer your question?
It's like how you define personality.
Yes, okay. Give you a few examples, okay?
Again, what I learned from some of the other students from, for instance, the UK, right? The thesis process. In Leiden, you get a personal guidance. For instance, every week in my case, I saw my supervisor and she informed me and she advised me on progress. Whereas in many countries, in many universities, you start your process. You have, for instance, once in the whole process, you see your supervisor. By the end, you submit it and you get your mark. And when you ask him or her, why did I get an 8? At many universities, you don't even get an answer. For instance, at LSE, well, I should mention of universities, I guess, but in this case, it was LSE London, and I happened to study there too in London. Indeed, you don't get to hear any feedback on what you did in your assignments, in your thesis, whereas at Leiden, I did get feedback, why I did things wrong and why I did things good. And that's just one example. Sorry? For courses too, yeah. Yeah, also for courses. Yeah, you get an assignment in a specific course, and you get feedback why you got that mark, and that's very good. That's instructive. These are learning lessons, right? And I was impressed with that.
Yeah, and I think the personal approach. I think that also, the excursions we have, the social activities we have, you will become a real community within your program.
And I assume that with the first beginning of the program, it's time to one supervisor.
Sorry?
Yes, it's different. Actually, every program, the supervisor is there for the thesis, and the thesis has to be written in the second semester, so it's a little bit later. But the way the programs are designed is every program has a program coordinator who will be the first contact person if you have any questions. Then we'll have an academic coordinator, which is Henk. So if you have questions about, all kinds of academic questions, you can go to Henk. And then every program, of course, has a program director. And they're the boss. They decide what will be in the program, etc. So these people, you see them during various activities, of course during courses, but also during social activities. And then once you start with your thesis, then you will be assigned a supervisor who will be your main contact for your thesis.
Yes, actually, it's really interesting, and me myself have a lot of questions, but unfortunately, we have really limited time. Okay, for the last question. Yeah.
Some of us
Okay, my name is Vidya. I represent my friends here who currently take a PhD program in Indonesia. I think last month or whatever, previously our professor in here said we have a library visit or library study program. One of them is joined with Leiden University. Can you explain more about this program and how we eligible to get there? And maybe if there's some tuition or maybe TOEFL or something that we have to any requirement that we have to fulfill before we apply to or we connected with Leiden. Can you please explain that?
Unfortunately, my office is only responsible for international education. I know there's a program like this because we talked about this with the colleagues from UI. And we'll be in touch with them also to develop a new program for PhD researchers to come to Leiden and do research, etc. I think for now it would be best, because I don't want to give wrong information, I have business cards with me. You can get my business card, and if you send me a message, I can forward you to the right persons who can tell you more about this. Because, yeah, unfortunately, I know a lot about education, but not about research. So,
Thank you for the question and thank you for the presentation. It's really interesting. But unfortunately, we have a very limited time. If you got any more question or interested with the program in the Leiden University, you can contact Indonesian representative of Leiden University with Ibu Rosa, and you can probably take the brochures here after this session. So by the end of the session, it closed all the event today. But for the final speech, there will be a speech from APPHGI, Asosiasi Pers, ya, untuk for the final speech.